paperwork's different. Okay, writ of attachment, there it is. This is the domestic situation,
That's the one that we ROR and
Support.
we give them their returnable date.
child support.
Yes.
So he has been ROR'd?
You have to announce it on the record.
Okay,
The order.
so there was a bond amount of 47,000.
Mhm.
And we're going to ROR him
According to, yes,
according to,
the order.
okay. This is due to the COVID. All right, this is Daniels.
Are we
Mr.
doing
Daniels?
interpreter first, Your Honor, right?
We have the writ first.
Just stand by for a minute.
Okay.
Hey, Gordon, you right, you read first.
Copeland. Come on, Copeland. Stand right here. Yeah, just right, okay.
Okay, so what is your name?
Jamie Copeland. Jamie Copeland.
Ah, okay, you're this one. All right, and this one is,
It's the second name listed on there, Judge. Sorry.
okay.
See how it says? Yeah, his name is on it. It's the
Uh,
same case.
My brain is
It's not
not here.
normal.
All right. All right, so you have child support issues. It looks like we're going to release you ROR. All right, and he's going to get a notice for a telephonic hearing.
Yes, and the time and the date should be listed on the first sheet. On the actual order. Yeah, it's typed on there. If you can just plug it in.
Okay, there's a phone number on here for you to call. Let's see a date.
Let me see if I can show you where it is.
All right, maybe here it is. Order release and direct and mandatory appearance at hearing. Okay.
So they'll be reinstating my bonds that I was out on?
Okay, so your next court date is August 17th at 9:30. And this is the telephonic?
Yes,
Okay, and that's on the other order I signed?
yes.
All right, and you'll be getting these documents that explain your time and your call-in phone number, okay? So
Okay.
you'll be released.
So I'm out of here today? You reinstate my bonds and I'm good?
These are RRs.
The only thing we're addressing is the writ, the child support writ. That's it. We don't have the other cases on the docket for today.
And so technically on the writ, is he ROR?
Yes, as to the writ only.
Okay, yeah, we're only dealing with the writ on the child support. I don't know if you have other holds. If you do, then you're going to be held until those are dealt with.
Is there any way that I can get them, cause I got my bonds were revoked for the writ and, you know, I don't,
Well, you'll need to talk to your bondsman or a public defender if you have them on your other case.
well, they were revoked for the writ. My bonds were revoked for the writ by me being brought in. They
Okay, and you have a public defender on those other cases?
no sir, I just got I couldn't
You what?
I don't know what's going on. I just know my bonds were revoked, and they told me I had a $42,000 writ, but I hadn't already taken care of this here before. I purged out for $3,000, and it came back. It said that I had a $42,000 hold on me for a writ for child support, but this was already taken care of. It revoked
Well,
my bond.
you're being released on that right now.
Yes, but I was out on bond and they revoked my bonds. So but my bondsman didn't come off my bonds. My bonds were revoked by me being picked up and charged with this.
Pre-trial release, is there any way you can assist and let us know what he's been going on?
He was brought in on an aggravated and battery charge on the, July the 8th.
So July
He was
8th, you had an
coming in for
aggravated
those.
battery charge, and what
He was
else?
coming in for those charges, his other charges was revoked, the ones that he was out on bond on. So the child support is not why his cases were revoked. It's because he came in July 8th for aggravated and battery. He had an open case.
They're not pressing charges on that. That I was stabbed. I got stabbed and I got charged with the aggravated battery for what the people did to the man, getting them off
All
me.
right, we're not getting into all that right now. Does he have a public defender appointed on those cases?
I'll make a copy. Does public defender know if he's a client?
I only have that he's here for the writ, and you just
Right.
appointed us there, but I don't know if we are his appointed to his other cases.
PD was appointed, Your Honor.
All right, so you do have a public defender. There's a public defender here.
Mr. Copeland, this is
Yeah.
Pedro Matos. I'm with the public defenders. Please don't speak on the facts of your other cases. Just give your public defender a call, and he'll be able to explain to you what's going on.
So will my bonds be reinstated for my other cases though? If my bonds are
we're gonna-
reinstated, then I can be released. I can go back to work. I
I understand, Mr. Copeland. Just give a call to your PD downtown that has your other cases, and he'll be able to tell you exactly whether your bonds were revoked or not. You will have the PD's phone number given to you.
Oh, you already signed it. Okay.
all right.
Okay, so then we have our interpreter case.
Okay, good. Now we have to add the interpreter in. So you're gonna hit on the white screen in front of you. You're gonna hit the plus button.
Plus button,
Yeah.
add,
And then click interpreter
interpreter,
and then call. Or add, sorry.
at,
Yes. And then it should connect us with him as well.
Good morning, Your Honor. This is Dalia Romero, Spanish interpreter on the line, not sworn in yet.
not sworn in, okay. Swear you-
Not yet, Your Honor.
Okay,
Do you solemnly swear and affirm to translate from Spanish to English, from English to Spanish, the whole truth and nothing but the truth, so help you God?
Yes, I do. Dalia Romero, state certified Spanish interpreter.
Thank you.
He can hear the interpreter, Your Honor.
yes, have you communicated with him yet? Can he hear you?
Yes, Your Honor, he can.
Okay. All right, and what is your name?
Edward Latorre Adorno.
Edward Latoro. Okay.
Okay, you have a charge of battery domestic violence. Do we have a victim present? Do we know? No? Okay. It's currently set at no bond. I'm going to set bond. I'm going to order you to have no contact with the victim. That means no electronic communication of any sort. You do not have anybody else contact her on your behalf. We'll appoint a public defender. And State, do you
How
have
can I
any,
pick up all of my belongings?
do you have any history, State?
There is no disqualifying history for him. There are some minor. There's a no valid driver's license conviction. However, the state would ask the court to also order that he not return to the scene, that he maintains a separate residence, and that he possesses no weapons, firearms, or ammunition.
You're ordered not to possess any weapons, firearms, or ammunition. You're to have a separate residence. You're not to return to the residence.
He qualifies for PTR, Your Honor.
You what?
He qualifies for PTR.
And Your Honor, the state would object for the record because the victim is not present.
Because of the what?
The victim is not present to provide input.
All right. I don't know the situation out here. Has the public defender's office spoke with these people yet or not? Or do you know anything or?
Your Honor, I do not know if with, his other attorney have spoke to him, but you are the one that assigned us to him. So once you assign us, then he becomes our client. He's already assigned.
And Your Honor, I'm not sure if you heard he did ask
I can look at that.
how can he return his personal belongings from the property.
Right, that was what I was going to address. I'm going to authorize him to return one time to pick up his personal items, but only with law enforcement. And he'll need to contact the public defender's office. He has nothing in his history, violent or anything?
No violence, no, Your Honor.
Does he have any way to bond out on a $2,000 bond?
No,
No?
no, Your Honor.
Can't hear it. Nothing blowing up there, I can't hear with a crap. So State, are you objecting to pretrial release?
Your Honor, the state will defer to the court on pretrial release. The state will put on the record he has no violent crime history. The only history he has is driving without a valid driver's license.
Yeah. I'm gonna leave the bond, like I mentioned earlier, at $2,000. And with the stated conditions.
So I won't be able to get out today.
Okay?
Your Honor, he asked if he's not able to get out today.
There's a $2,000 bond. As soon as he posts that, he can be released, or he can set up a bond hearing if he needs it reduced.
I don't have anyone here to help me.
Yes, you do. You have the public defender. They've been appointed for you. All right, what is your name?
Pedro Hernandez Montañez.
Pedro Hernandez Montañez.
All right, this is a Division 20 case. There's an arrest warrant for sexual battery on a child under 12. That's no bond. Public defender will be appointed. That will stay no bond at this time.
Your Honor, the public defenders would like to make an argument for bond in this specific case.
This is battery under 12.
And Your Honor, it was a 7-year-old child,
Yep.
his granddaughter.
It's going to stay as indicated by the judge that issued the arrest warrant at none at this time. What's that? I will order him to have no contact with the victim.
And Your Honor, the state would request no contact with the victim or the victim's family, no contact with anyone under the age of 18, no weapons, firearms, or ammunition, And if he has a passport, that he is to surrender his passport. And,
He's not getting released. He's going to have to see another
no,
judge.
no,
for a
Your
bond
Honor,
hearing.
but should he have a bond hearing and does obtain bond, the state would ask that that order be put in place at this time.
Well, you'll have to get a bond hearing, and that judge will address that issue. I'm not releasing him. I'm just going to order him to have no contact with the victim in this case at this time.
Thank you, Your Honor.
Judge, Your Honor, my question is, so you did find presumption great and evidence, presumption great and proof evident?
I just have the warrant. I don't have any factual basis. Does anybody have the factual basis?
Yes, Your Honor, if the court, unfortunately, this is highlighted,
Oh, mine,
if the defense doesn't object.
mine is not highlighted, but I do not object to it.
All right, may I approach, Your Honor?
Appears to be sufficient evidence. If you want to set an Arthur hearing defense, you can do that with the appropriate judge.
Thank you, Your Honor.
What would I do? I need help. I don't have anyone here.
You have the public defender appointed. They will be out to see you as soon as they can, or call you, or however they're going to do that in this era.
That's a no. That's all with Spanish interpreters, Your Honor.
Is that it for the interpreter, Your Honor?
Is that it for the interpreter?
Yes, sir.
Okay, I guess that's it for now, interpreter. Thank you.
You're very welcome, Your Honor. Have a great day.
We're doing the Portuguese next?
We're gonna do Portuguese at the end.
We're going to do that at the end, evidently. Don't forget, because I forget. I'll get up and go home and go, oh.
Oh, you know it's first and second session, so we have to pull out second session. Are
So
you
it's all right here?
You have everything right now.
Oh,
So
okay.
after the 30-day motion, that's second session.
Okay. So where are 30 days? Are they over here?
They're in your stack. Yeah. Just know when you get to those, that's it for first.
Okay. But we're going to keep going, or we need a break?
We'll probably need a break. We'll ask them when they'll be ready to come back.
Okay. Okay, let's see. What is your name?
Carlos David Antuna.
Ah, somebody spoke up out there. All right. Have a live body.
On behalf of Carlos Antuna.
Okay, and this looks like a Division 10 VOP set at no bond.
Yes, Your Honor, I'm actually here to request a bond be set on the VOP.
Judge Conrad. Wow, this must be old. So 93? Is that what it is?
That is correct, Your Honor.
The underlying case was 93. I believe the VOP was 1994.
94, yep.
Typically, I would not set a bond on a felony VOP when the judge didn't do it, but because this is old, State, do you have any input?
Well, acknowledging the fact that he's not entitled to bond, the state would recommend that the court set bond in this matter at $5,000.
Okay, that seems fairly appropriate. Defense?
Yes, Your Honor.
Okay, so I'm going to set a $5,000 bond on this case. And have you filed a notice of appearance yet, or are you?
Yes, Your Honor. I'm actually covering on behalf of Simon Wiseman.
Okay, so he's in the case for good, not just
Yeah.
for the bond hearing type thing?
Yes.
Okay, so we'll set bond at 5,000.
Thank you, Your Honor.
Okay.
May I be excused, Your Honor?
Okay.
May I be excused, Your Honor?
Yes, thank you.
Thank you.
Okay, what is your name?
My name is Kyle Dossett.
Okay, Mr. Dossett. All right, and there's not a victim here on this. I think this is your father.
Correct.
Okay. Looks like too much alcohol involved here. State, anything on this case? He qualifies for pretrial release? Yes.
And, Your Honor, if I may have just one moment. Is this Mr. Dossett, Your Honor?
Yes. Him and his father were drinking and
Your Honor, this state would recommend on count one, a bond of $2,500, count two, a bond of $100 as a subsidiary. The state would also ask the court to order that he have no contact with Keith Dossett, that he maintain a separate residence, that he possess no weapons, firearms, or ammunition, that he possesses or consumes no alcohol or controlled substances.
all right, so Mr. Dossett, we're going to go ahead and appoint the public defender for you.
Okay.
State's requesting a $2,500 bond and a $100. You able to make that?
Yes.
Okay.
Oh, I should. At least the 100. I don't know about the 25, but I think so.
Hey, based on the facts, I'm going to set your bond at $1,000 and $100.
Okay.
Order no contact with the victim. You don't live together, right?
Correct.
So you have to have a separate residence. You're not to return to that residence
Okay.
at this time. No contact at all. You understand that?
Yes, sir, Your Honor.
All right, and then your public defender will help you with it, or unless you hire a private lawyer.
Okay.
And is the court going to order the no alcohol or controlled substance? And the no weapons?
I always have a problem ordering no alcohol if alcohol's a drug, okay? I'm not a doctor. I don't know if this man is addicted to alcohol. And if he is addicted to it, and he follows my order and does not consume alcohol, he could actually die. I have seen that happen. Not personally, but through various medical channels I watch on YouTube. People actually have withdrawals and die because they stop consuming alcohol. So I'm not going to tell him not to consume alcohol. I'm going to order him to stay away. So that's
Will
one
there
for
be
you
the
two.
customary weapons order, or in domestic violence, we typically
Okay,
order?
I'll order you not to possess any weapons or firearms.
Okay.
I'm assuming you don't need a firearm for work.
No.
Gotta fit YouTube in that at least once. All right, what is your name?
Mark Vaughn.
Okay. All right, I'm gonna give this judge a rest and
Good morning, Mr. Vaughn. Can you give your date of birth?
August 20, 1980.
All right. You have been arrested on 2 charges, one of possession of controlled substance and the second domestic battery with a notation of domestic violence. I reviewed the affidavit. I have found probable cause for your arrest for both charges. As a count 1, of course, want to release you on your own recognizance. As a count 2, I'll set bond in the amount of $1,000 with pre-trial release conditions that you have no contact with the victim, do not return to the scene.
Your Honor,
Yes,
the
sir.
victim is also in Orange County Jail.
I know.
All right.
We have the victim also in the courtroom, Your Honor, if you want both of them to be in here at the same time.
We can do both. Miss Tiffany Vaughn,
Yes, sir.
can we give you your date of birth?
7/27/80.
All right, you have been arrested on a charge of aggravated assault, domestic violence. Your bond is currently set at none.
I'm sorry, what was that?
Your bond is set at none. This is $0. I want to set bond in the amount of $1,000 for you as well. I will order both of you to have no contact with each other, for you to both live at separate residences.
We live
For
together.
Mr. Vaughn, say again?
We live together. We're married.
Yep, I know. Somebody's gonna have to leave. So right now, it seems like Mr. Vaughn was already trying to leave, so
Right.
we'll let him leave.
Okay, I just wanted to make sure you understood.
Yep, I got it. That Mr. Vaughn not return to the scene.
Can
That
you get,
if you can return one time with law enforcement, he has to call law enforcement first, and then get them to go with him. Don't go there without law enforcement. Retrieve whatever the rest of his personal belongings, and then he can go to a separate residence, and Ms. Vaughn, you can stay at the home.
okay.
Mr. Vaughn, I'm going to order as well that you do not consume any illegal substances to which you don't have a prescription.
Yes, sir.
Okay. All right. And you're going to be subject to pretrial release, both, and that you will be subject to random testing. Okay?
Yes, sir.
Were you ordering him to do PTR on
Yes.
count 1 or RR?
You are on count 1.
So count 2. Okay, so
Count
you
two.
want bond plus pretrial release.
Bond
and you
plus
want
pretrial
him,
release, that's count 2.
and you want him drug tested.
When drug tested,
Okay.
for him not to return to the scene, for him to remain, to have separate residences from the victim.
Okay. I'll have him look at just that.
And then he's not to consume any alcohol or illegal drugs.
He wants bond plus pretrial release. Yeah. And are you waiting? Yeah. Okay.
And that's the Mrs. Vaughn, that's Tiffany Vaughn, and then she's for $1,000 with pretrial release conditions with her, for her not to return to, well, for her to have no contact with the victim in her case, which is Mr. Vaughn. That they were to maintain separate residences, but she can return to the home. So I want that to be clear, that Mr. Vaughn is not to return to the home, Mrs. Vaughn is to be able to return to the home.
You're ordering the PD?
Yeah, and the PD is appointed in both of your cases, but because obviously there's obvious conflict, somebody's going to get the PD, somebody's going to get probably a regional conflict counsel, which is somebody that can represent you independent of the next person. Okay?
Okay.
And your future court dates are on demand. Well, that's your future court dates will be on your paperwork.
And Your Honor, the state would ask for both defendants if there could be a no weapons or firearms order.
Because of the type of weapons in this case, there are the proposed, I'm not gonna order that right now.
All right.
I don't think the speaker, I don't know if it meets our definition of weapon at this point.
Thank you.
Is this Mr. Whitted?
Yes.
Can you state your name?
Jonathan Whitted,
Can you give me your date of birth?
November 6, 1990.
All right. Mr. Whitted, you're here on a charge of aggravated battery on a pregnant person with domestic violence in nature. I don't think you said there are any victims here. I want to appoint the public defender to represent you in this case. I wanted to set bond in an amount of $15,000 in this case with pretrial release conditions that you have no contact with the victim, you not return to the scene, must maintain separate residences, may not possess any weapons or firearms, including a common pocket knife. And if you have any of those, you want to surrender those to the Orange County Sheriff's Office. And I think your next court date would be on demand.
Are you giving him like a certain amount of hours to surrender?
I give him 48 hours for his release.
Okay, I'm sorry to interrupt you. Just trying to make sure we're on the same page. When you say bond with pretrial release conditions, you're ordering bond plus pretrial release. Okay.
And then how much? And what was the bond amount?
$15,000.
$15,000.
Thank you.
This is Ms. Wilkerson.
Yes, sir.
How are you? Can you state your name for the?
Kiara Denise Wilkerson,
All right. And give me your date of birth.
January 10th, 1994.
Ms. Wilkerson, you're here on a charge of assault, domestic violence. Your bond is currently set at none. I do find probable cause for the charge in this case. I will order bond in this case of $2,500 with PTR, no contact with the victim, no return to the scene.
Yes, sir.
Must maintain separate residences, may not possess any weapons or firearms, including a common pocket knife or any chemical agent. Unfortunately, Ms. Wilkerson, you're also here, you're out on bond in 2020 CF 5947AO on a charge of driving license suspended. Also, you're out on bond on, as well as a charge of grand theft and possession of methamphetamine. Because you're arrested on a new charge, in this case, the court finds that no pretrial release conditions are appropriate at this point, and I want to revoke your bonds and discharge them. That's a 20 CF 5947AO.
So what does that mean?
Good.
2,500 on the
Aggravated. I meant of
the
the
assault.
And then for grand theft,
It says 0.
it says 2.
I'm saying it at 0.
Oh, you said
Revoke
that.
your bond.
Okay, you're talking about the out on bond cases?
Out on bond cases.
Okay, so the out on bond cases, the case numbers are in the body.
Oh, sorry.
Yeah, she has another case.
Yeah.
Oh, sorry.
she has
That's
two
okay.
cases.
Oh, Ms. Wilkerson.
Yeah, me and her.
We need a bet.
Yeah, she has a grand theft, third degree.
And
And
she's,
also,
and she's out on bond on 2 cases, which is the 2020 CT 2566 and then 2020 CF 4686.
She was like, yeah, and then she had, and then this is a new charge. Okay.
Anytime you see those
So I thought all
gold
this was
papers, yes, anytime you see those gold papers, there's always another case underneath it.
I'm sorry, Ms. Wilkerson, I apologize. You are out on bond on 2020 CT 2566 AO. In that case, someone will set your bond, or discharge your bonds and set them at none. You are also arrested on a new case in 20 CF 5947 AO for a charge of grand theft motor vehicle. I want to order that your bonds be set in that case in the amount of $2,000. I'll stay those bonds and order that you have no contact with the victim and no return to the scene. As far with her PTR that she's already on.
For both cases?
For both cases.
Okay.
So you have to have a bond hearing as to your traffic case. Okay?
I'm confused.
And, Your Honor, on the second out on bond, the grand theft and possession of meth, that was revoked
Yeah, that
and
was
set
revoked
at
as
0
well.
as well.
And
Thank
then
you.
also your bonds revoked in 2020 CF 4686 AO. I want to revoke and discharge your bonds and set them at none.
I don't get it.
Yes.
Oh, Your Honor, what does that mean?
You're gonna be on, you have bonds, that's the new cases, to the assault, domestic violence, and to the grand theft motor vehicle cases. But your old cases that you had already bonded out of, you're gonna be held on no bond right now.
So I can't
you
bond
have to
out.
Can't bond out today. You have to address those cases with the judge that you have in those divisions, okay?
Okay.
All right, you have a good day. The public defender is appointed to represent you in all your cases.
I know, because we weren't expecting.
Yeah, exactly. Back to you, Judge.
Okay. Record Judge Shoemaker back to my little break. I like that little break. Pretty good. That's pretty good. All right, what is your name, sir?
Jonathan Davis.
Who is this?
Davis?
Misdemeanor domestic.
Page 5.
Okay, let's print it out real quick.
What is your first name?
Jonathan.
He was the only misdemeanor domestic.
Joshua did.
Print it out. You got it. We're gonna print it for you, Judge. Give us 1
Okay.
second.
All right, we got to pull yours up here. We don't have it. Just a minute.
You want my copy?
Do we have one? Jonathan Davis. All right, you have a charge of battery, domestic violence. Read this real quick. Oh, I did read this. I have this. Yeah, it's somewhere in there, all right. All right, so there is probable cause for the domestic violence charge, so the victim is not here. I'm going to order no contact with a victim, separate residence. State, you have any other input?
And the
This is
state
basically-
would recommend that there be allowed a one-time law enforcement return to get personal
Yeah, this is
belongings
Basically a battery where he grabbed the keys out of his, I think, his mother's hand.
out of his mother's hand. Yes, Your Honor. And there's no indication that alcohol was involved. So the state has no further requests.
All right. So I'm going to set your bond at $1,000. That's, you'll need $100 to get out. Can you make that bond?
Yes, sir.
Okay. And then the public defender's appointed. Returns, again, no contact with your mother. You understand what that means?
Yes, sir.
None at all. No electronic communications, nothing. Okay. What is your name?
Marcos Costa de Oliveira.
The next person was on the docket, Angelica Perdomo, bonded, Your Honor.
Okay. Bonded. What is your name again? What is your name?
Marcos Costa Oliveira.
This is Portuguese.
Português.
Oh, interpreter case.
Aqui, Júlio.
Oh, the Portuguese one.
Your Honor, Bannister is medical.
He's the Portuguese interpreter case?
Yes, right here.
Custom Marco.
Okay, we're going to see if we can get the interpreter online.
You said Bannister is medical. Portuguese.
You have to push something up here again?
Okay, Judge. On the black screen, the black box, you're gonna hit the, not that one, the one in front of you, yes. Hit the talk button. Now the interpreter should be on.
All right, do we have the interpreter?
Yes, the interpreter's on the line.
Okay, and so she's not through a headset with him, right?
No, I had to use the language line.
Okay. All right.
Judge, maybe ask her if she can say a few things to him to make sure that they can hear it.
All right, can you go ahead and speak to him in Portuguese and see if he understands you?
Olá, senhor, eu sou a intérprete. O senhor consegue me escutar e me entender?
Consigo sim, entendo sim.
Yes, he can understand and hear me.
All right, ask, what is your name, sir?
Senhor, qual é o seu nome?
Marcos Costa de Oliveira.
Marcos Costa de Oliveira.
Isso,
All right, you have a charge of battery, domestic strangulation.
Você tem uma acusação de agressão, estrangulamento doméstico.
And also a charge of battery for striking allegedly the victim in this case.
E você tem outra acusação por ter batido na vítima nesse caso.
I'm going to order you to have no contact with the victim
Eu vou colocar uma ordem para que você não tenha nenhum contato com a vítima.
Ok.
You're not to return to the residence where this occurred.
Você não pode voltar para a residência onde isso ocorreu.
And no contact means no electronic communication, no cell phones, zero contact, no face-to-face contact.
Não ter contato também significa nenhum tipo de contato eletrônico, nenhum tipo de contato físico, pessoal.
Perfeito, entendo sim.
I understand.
I'm going to appoint the Public Defender's Office to represent you on these charges.
Eu vou colocar o escritório do defensor público para poder te defender
Does the state have any
dessas
input on this?
acusações.
Anything from the state on this?
Ok.
No, Your Honor.
Judge, he also has an immigration detainer.
He has an immigration detainer?
Yes,
Okay, so the public defender is appointed. Any history at all, state? Do you have any?
There is no history, Your Honor.
Okay. So on the battery strangulation, the bond will be $2,500. On the misdemeanor battery, I'll set that one at $100.
Ok, então na agressão e estrangulamento a sua fiança é de $2.500. No delito de agressão eu vou colocar a fiança em $100.
All right. Anything else, state?
Nothing further from
Okay.
the state, Your Honor.
Sim.
Yes.
All right, thank you, interpreter. Go. You just hung up on me, huh?
Judge Shoemaker, we still have to call those in jail arraignments on the record. What they've been doing is, if they're medical, the judges have been waiving, well, defense has been waiving their appearance, public defenders being appointed, and we give them dates. Only for medical though.
All right, so the in-jails are these?
Yes, you should have a total of two, just two. Mr. Bannister and Mr. Reese.
Reese R.
We'll call Bannister first.
Okay, so on Bannister,
He's medical, Your Honor.
And Reese has been RR.
you what?
Reese is not.
Reese is gone? Reese is released?
Yes.
Okay, so we won't deal with Reese. These are the arraignments.
Yes, the in jail
So
arraignment.
he's been in jail for 29 days.
Yes, and he has a public defender already, so.
Okay. Is this something that's applicable or?
However, Your Honor, he's not in jail on this matter for 29 days. This was a notice to appear.
It was transferred. He's in jail on this case. It was transferred from a felony case.
Okay. This case was done by a notice to appear.
I haven't been in jail since 6/17.
He does have a, are you looking at 2020 MM 1377?
It was transferred from 2020 CF.
Joshua Davis.
He has a battery, so he's not available.
Right. And, well, Joshua Davis is a resisting.
He's resisting?
It's a resisting without violence.
Okay.
But
Oh, no, I'm sorry.
I wouldn't give you an offer on him anyway.
Okay.
And so you might have a problem with him. He's a sovereign citizen. So he may not recognize you as a defending attorney because he doesn't recognize the laws of. Sydney Hogan.
What's the first one this afternoon? What's the name? Burks. That's the one.
She has too many priors, so there's no option.
There was another one.
Lockhart is a battery, no offer on that. Jesus Marquez also has another trespass.
All right, let's go ahead and get the state attorney and public defender's names on the record.
Good afternoon, Edith Bush for the Office of the State Attorney.
Good afternoon, Your Honor. Pedro Matos for the public defender.
Okay, are we on everywhere we need to be? Everything good? All right, ready to go. Okay,
Good afternoon, Your Honor.
hello there.
How are you again?
We're going well here, we're doing well.
I'm getting you first person.
Okay.
Yeah, so don't.
I need work.
All right, what is your name?
Patrick Burks.
Okay, this is Burks.
Hold on for a minute. Just hold on, Your Honor. Who you paying for? Eight.
All right, what is your name again?
Patrick Burks.
Burks, okay, you're here on a trespassing charge. Again, I made probable cause determinations on all of these cases, unless I state otherwise. We're going to go ahead and appoint the public defender on your new trespassing charge. Is this a pleable case, State?
It is, Your Honor, and the state is prepared to also give him a global offer on his out on release case under 2020 MM 4147AO. And that is also a trespass, same victim. And the state's offer would be, in both cases, adjudication of guilt, credit time served. In the current case, he has 2 days credit time served, no return to the scene, abide by all trespass warnings, and no contact with witnesses and court costs. And those are the same conditions in the other. I do not know the credit on the other. 2 days. So he has 2 days credit time served in both cases, Your Honor.
Okay, the public defender is appointed.
Mr. Burke, I just want to ask you if you do understand what pleading to these two charges would do, and if you do want to plea out so you can get out today.
He's talking to you, bro.
You didn't know that you were talking to him.
Mr. Burke, can you hear me?
Yes.
It's Pedro Matos with the Public Defender's Office. I just want to know if you want to plead the two trespasses, and if you do understand that you'll be getting adjudicated guilty on those charges.
Yeah.
You got to speak up.
Yes.
Yes, you understand?
Yes.
Well, Your Honor, if he understands, then I will allow him to proceed with the plea.
Ask him if he wants to accept the offer.
Mr. Burke, would you like to accept the offer by the state's attorney?
Yes.
Burke, you're not saying a whole lot. Do you understand what your charges are?
Yes.
What are they?
Trespassing.
All right, you know what trespassing is? You know what that means?
What does that mean?
What's that?
What does that mean?
What does trespassing mean?
Yeah, well, going to a place that you can't go.
I can't understand.
Your Honor.
Going to a
Going-
place that you
going to a-
can't go.
Going to a place that you can't go.
Okay, so someone tells you to leave somewhere, you have to leave. And if you've been told not to come back and you come back, that's basically trespassing. I'm just trying to determine whether I can take a plea or not. I'm not sure you're really with us or not. So you understand the charges of trespassing?
Yes, I do.
The Public Defender's Office has been appointed. Do you need more time to speak with them before you resolve these cases?
Let me just ask him one more time, Your Honor, just to make clear.
What?
I'm asking one more time, Your
Okay.
Honor, just to make clear. Mr. Burke,
Yes.
you're being offered to resolve both of your trespass today.
Okay.
We need to know if you can understand what resolving and getting adjudicated for this and accepting this offer would do for you. If you do not understand exactly what's going on, then we will not plea you out and we'll proceed to pass this on to your attorney downtown.
No, the first thing you said
About your plea. Do you understand the plea? Can you reiterate it back to me? Your Honor, I do not feel comfortable accepting this plea right now.
accepting the plea is what I'm thinking.
But do you understand what the plea is?
Yeah, the first thing, yeah.
So if you plead guilty or no contest today, you're going to be released, you're going to have convictions on your record, and you're going to have court costs to pay, and you're not to return to this location.
Yes, I will accept.
Do you understand all of that?
Yes,
Is that what you want to do today?
yes, sir.
Now, have they seen plea forms or anything?
They don't, they're not doing them on the misdemeanor cases.
Okay, so by pleading out, you're going to be giving up your right to have a trial, to be presumed innocent at trial, to confront the witnesses that testify against you, to have your attorney represent you in trial, to be presumed innocent. Those are kind of your basic rights you're waiving and giving up. Is that what you want to do today? Waive those rights?
Yeah, I want to accept the plea.
You got to speak up.
Yes.
Okay. Do you have any questions about anything?
No.
No? All right, so the one he's out on bond, that's the 20M 5131?
No, Your Honor, it's the 4147.
4147. Oh, there it is. Okay. And do you have a factual basis on that one, State? I don't know anything about that one.
Yes, Your Honor. On June 7th of 2020 in Orange County, Florida, the Chevron manager at Bruton Boulevard Chevron saw the defendant on the property. He told the defendant to leave multiple times. The defendant continued to return to the property, and he reached toward his waistband, raised his hand in a manner of a firearm. The manager called law enforcement. And the defendant had previously been trespassed from the property located at 3250 Bruton Boulevard.
And both cases happened at the same location?
Yes, Your Honor.
All right. So any questions at this point?
No.
You know, I'm going to order you not to go back to that location, and if you do, you're going to be in jail for a long time, more than likely. You understand that?
Yeah.
Okay?
Yeah.
Yes?
Yes, I understand.
All right, then to your trespassing charge, the facts that she just went over on the record, looks like that one was from June 8th. What is your plea? Guilty, not guilty, or no contest?
Guilty.
What is it?
Guilty.
Guilty. And then your one you're here on today, which was from July 14th at the same location, trespassing. What is your plea on that charge?
Guilty.
All right, I'll accept your guilty pleas. I'll follow the agreements. On each case, you'll be adjudicated guilty. Each case, you'll be credit for time served. Is it 2 days on each?
Yes.
Okay. We'll put the court costs just on one case. We'll consolidate them for sentencing. So you have court costs to pay. And we'll place you on a $20 a month payment plan with the clerk's office. And we're going to start that on, calendar. What's the last Friday in August? August. 28th? All right, August 28th, at least $20 a month. And no return to the 3250 Burton Boulevard, Chevron.
Yes. Thank you.
Mm-hmm.
Come on, Dave.
All right, what is your name?
Joshua Davis.
Mr. Davis, you're here on a resisting without violence charge. We'll appoint the public defender's office. Is this applicable?
No, Your
No,
Honor.
Your Honor.
No? Does he qualify for pretrial release? No? He's on state probation? So is there an on-view violation, or?
It's an on-view, yes. And he has a violent offender.
He what?
He has a violent offender home, I-J home,
Okay.
to give that probation officer opportunity if there's a violation.
Okay, so I will set a bond on this, $2,000 bond. Public defender is appointed.
Is that a bond on the VOP or what?
I can't understand what he's saying.
Is that a bond on the VOP or the charge?
We're not dealing with the VOP yet, right?
So you raising the bond on
And put it at 2,000.
it? So you raising the two?
We don't have his VOP, right?
No, it's an on-view VOP, but he has that 5-day hold.
Okay, they'll probably bring you back to court in a few days for that.
So why is the resisting arrest $2,000?
Yes.
What's that about?
What's that?
Why is the resisting arrest $2,000?
Are you asking me a question?
Yes, sir.
What is your question?
Why is the bond on the resisting arrest $2,000?
Because that's what I think is appropriate. Talk to your public defender. They can file a motion. What is your name?
Sydney Hogan.
Ms. Hogan, you have a prostitution charge. We'll appoint the public defender's office. Is this applicable, or?
It is not, Your Honor, based on her extensive history of the same crimes. It's an enhanceable charge.
All right, the bond is set at $1,000. Public defender's appointed. All right, Lockhart's next. What's your name?
Shaquanda Lockhart.
Okay,
Judge.
you have a new charge of battery.
Yes, Judge.
I'm going to appoint the public defender.
Can I say something to you?
Your public defender probably doesn't want you to say much of anything, but
I don't
Ms.
care.
Lockhart.
I don't care nothing about no public defender. I'm telling you what's real, like what's what.
or whatever you
Ms.
say
Lockhart.
is being recorded and can be used against you. I
Okay,
can tell you right,
okay.
I can already, ma'am,
I
I can
already-
already tell you, I'm revoking your bonds and your delivery of cocaine cases. They're going to no bond, so you're not getting out of jail no matter what you tell me. So on your new battery charge, I'll set your bond at $500, no contact with the victim.
So I don't got no bun.
Right, your public defender's office, is the public defender on the prior cases?
I can tell you right now, Your Honor.
No, let's go ahead and get the public defender appointed.
So what you saying, I can't bun out?
No, you cannot bond out until you see another judge.
So when I see another judge?
That's when your public defender will set up a hearing with the judge.
Well, public defender, get on your job, please.
All right, your name?
Jesus Antonio Marquez Jr.
Okay, you have a new trespassing charge, and it says you're out on bond for a trespass after warning. Public defender is already appointed on the prior case, and we'll appoint them for the new case as well. Is this a pleable?
It is, Your Honor, and the state's global offer to resolve both matters would be an adjudication of guilt in both. On the current case, 2 days Orange County Jail, 2 days credit time served. It would be a credit time served offer in the out on release case, and both cases would be no return to the scene. In the new case, the scene is the 7-Eleven on Forest City Road. And in the prior case, it is the Circle K, if I may have just a moment, on North Orange Blossom Trail. Abide by all trespass warnings, no contact with witnesses at either location, and court costs.
Okay, public defender is appointed. Do you need to talk to him for a moment?
No, Your Honor. If you accept the plea, we're willing to go with the state's recommendation.
All right, so you want to accept the plea?
Yes, Your Honor.
Do you need any more time to speak with the public defender before you do that?
No, Your Honor.
And you understand the charge of trespassing?
Yes, Your Honor, I do.
And you're not going to be able to return to those locations?
That's correct, Your Honor.
And by pleading guilty or no contest, you're going to be giving up your rights to go to trial, to be presumed innocent at trial, to confront the witnesses, to have your attorney represent you there. Do you have any questions?
No, Your Honor.
Okay, on the 2020 MM 4135, that's the one you're out on bond. What is your plea to that charge of trespassing?
Guilty, Your Honor.
And then on your new charge, trespass after warning, what is your plea?
Guilty, Your Honor.
All right, then I'll accept your pleas. And these were adjudications, State, on both?
Yes, Your Honor.
Enter adjudications of guilt, order you not to return to those locations. And you'll have court costs. We'll combine these for sentencing. Court costs will be on the 4135. You'll pay that through the clerk's collection program, starting August 28th, at least $20 a month.
Yes, Your Honor.
Any questions?
No, Your Honor.
Okay.
Come on, miss.
All right, what is your name?
Your name?
David Lloyd Middleton Jr.
Middleton, David Middleton Jr.
Yes, sir.
You have a charge of possession of drug paraphernalia. We'll appoint the public defender's office. Is this a pleable?
Yes, Your Honor.
Yes, Your Honor, it is. And it would be an adjudication of guilt, 2 days Orange County Jail, 2 days credit time served, and court cost.
Okay. If you plead guilty or no contest today, the agreement is you'll be adjudicated guilty. You'll have the conviction on your record. You'll have credit for 2 days in jail, so you'll be released on this case today, and you'll have court costs to pay.
Yes, sir.
Do you understand that?
Yes, sir.
Is that what you want to do?
Yes, sir.
Do you need more time to speak with the public defender?
No, sir.
No? Do you have any questions about anything?
No, sir.
All right, and you'll be waiving your right to go to trial, to be presumed innocent, to confront the witnesses, to have your attorney represent you? Any questions?
No, sir.
All right, then what is your plea to the charge? Guilty, not guilty, or no contest?
Guilty.
Guilty? All right, we'll accept the plea. And there's a factual basis, and we'll enter the adjudication, credit for 2 days' time served. Court costs, pay that through the clerk's collection program, at least $20 a month, starting August 31st, 30th? 28th. Okay, any questions?
No, sir.
Okay. All right, your name?
Stephanie Summers.
Summers, you're here on a prostitution charge. Public defender will be appointed. The bond is currently $500. Is this a pleable?
No, Your Honor, based on her history, and it's enhanceable.
All right, bond's $500. Public defender is appointed.
Your Honor, we would ask for a no return to the scene. A no return to the scene or the mapping zone in the state, and I believe we have the mapping zone.
Okay. She's still there?
Bring her back.
And she'll get a map of that area?
She'll get a description of the area that she's not to go to, plus she's not to specifically return to the scene of the arrest as well.
All right, so we're going to order you not to return to the location where you were arrested or the mapping zone area. That'll be explained to you on a sheet of paper where you're not to go.
Okay.
All right.
Come on, Bill.
Good morning.
Hello, what is your name?
Lazaro Vela.
Okay, you have a new charge of trespass. And you're out on bond for burglary.
I was ROR'd. The charges were not picked up.
Looks like the burglary was that charged as a misdemeanor, state?
Yeah, and it was not
Looks
picked
like-
up. They let me out because the charges were not picked up and the state had not filed on me.
Your Honor, the petty theft was a misdemeanor. The burglary was under 2020 CF. I believe it's 6.
They transferred it.
They transferred it?
Yeah, from
Transfer it to
20
misdemeanor.
to the 20 4994 AO.
So it was charged?
It says filed as a trespass.
Your Honor, if I may just look at that again.
Yeah, I think I received a letter in the mail. I think it was filed as a trespass, but I was still ROR'd, so I was not out on bond. I was released because the state hadn't filed charges at that time, and it was not picked up.
Now the computer has decided not to cooperate. So if that's the information that everybody else has, is that it was transferred, then
We have it, from what I saw on there was we have it filed as a trespass and a petty theft instead of a burglary of a structure and a petty theft.
So it was charged as what?
As a trespass and a petty theft instead of a burglary of a structure and a petty theft.
So state, what do you want to do? The old charges.
as to the out on release charge, the state would ask the court, as it's a similar case, to revoke the bond. The state will defer to the court if a new bond is set in that matter, or revoke the release. But I'll defer to the court if the court chooses to set a bond in that matter.
Is there any other history on?
Yes.
Yes, Your Honor. He has a total of 21 convictions, 3 which are felony, 18 which are misdemeanors, 8 failures to appear, the last of which was December of 2018. And his convictions are a mix of property crimes and domestic violence crimes, Your Honor.
I have been only convicted.
Your Honor? This is your, Mr. Bella, this is your PD. If you're gonna speak on any of the facts, please do not.
Oh, okay. Thank you then. I don't know you were a public defender.
Your Honor.
And he
His
also
last,
has,
go
I'm
ahead.
sorry, he also has juvenile adjudications, Your Honor.
Your Honor, his last conviction was for trespass on a structure other than the conveyance on December 6, 2019. We just have a trespass again. I would ask for you not to revoke his RMR, and if you do release him or give him bond today to lower it, to make it as lower as possible.
Sir, I was asking to maybe have a settlement with this trespass that I'm on now. I mean, I know that there's a possibility because it's a misdemeanor. I know it's a trespass. I know you can settle misdemeanors on your first appearance, and I would ask for a plea instead of going through having to waste any money or time on another court date. And I also would not like to have any more.
I understand, Mr. Bella. Let me ask for you. The PDs would like to ask the state if they would like to give a global offer for both trespass.
Actually, I would like to ask the judge. I mean, I want to ask the judge himself because I know he is in the seat to where he can make that type of judgment. I mean, I want to know if he can give me a plea on those charges because I mean, they're trespasses. I mean, I'm homeless. I mean, it's hard. It's hard, in the type of situation that I'm in, and I do not, intend to go and make it hurt anybody. I don't try to do things that get myself into trouble. I mean, but I've actually been doing better. My uncle has given me a chance. I've been living with him. I got a job. I was at a Wawa. I stopped at the Wawa to get a drink. I was sitting on the bench.
You're talking about the facts of your case, and
well,
I think your attorneys advise you not to talk about the facts.
Yes, sir.
So is this a pleable, or is it?
Your Honor, the state is not going to convey an offer.
Okay. So I'm going to revoke your ROR on the case you were out on bond. I will set a bond of $2,000 on that case.
But sir, is it
and 500 on your other case?
Is it a
Public defenders appointed.
So the burglar was dropped to a trespass? I don't understand why they're all
Mr. Bella?
misdemeanors.
Please, they'll give you your number for your PDs. Please talk to them. I'm gonna send them an email so they make a motion
But
to lower your bond.
if they're all misdemeanors,
Velasquez is
why
next.
don't I have a right to
Is next.
Don't I have a right to an offer if they're all misdemeanors?
Mr. Bella?
Judge, you paid his bond, correct, on the new case?
Yes.
You gotta pull it out.
All right, your name?
Fermin Velasquez.
Vasquez, this is a trespass on property after warning. Is this pleable?
Yes. Yes, sir.
Public defender will
Yes,
be
Your
appointed?
Honor, it is.
Okay, we'll appoint the public defender.
And Your Honor, the offer would be an adjudication of guilt, 2 days Orange County Jail, 2 days credit time served, no return to 1755 North Econlohatchee Trail in Orlando, and that's the 7-Eleven gas station. Abide by all trespass warnings and no contact with any witnesses and court costs.
No
All right,
problem.
so did you understand the offer? It's basically an adjudication of guilt,
Yes, Your Honor.
credit for 2 days in jail, so you'll be released on this case today. No return to that 7-Eleven gas station on Econlohatchee Trail, and you'll have court costs.
Yes.
You understand that offer?
Yes, Your Honor.
Is that what you want to do?
Yes.
Yes?
Yes, sir.
Do you need more time to speak with your public defender?
No.
No? Do you have any questions?
How much is the court fees?
The court costs, they're around $273 or so. And I'll put you on a $20 a month payment schedule starting the end of August,
Yes, Your Honor.
28th. Any other questions?
No. No, Your
All right,
Honor.
and your charge of trespass after warning, what is your plea? Guilty, not guilty, or no contest?
No contest.
What?
No contest.
No contest, all right. And by pleading no contest, you're giving up your right to go to trial, to be presumed innocent, to confront the witnesses, to have your attorney represent you. Any questions about that?
No, Your Honor.
All right, then I'll accept your plea, follow your agreement, enter the adjudication, credit for 2 days, order you again not to return to that 7-Eleven gas station at 1755 North Econlohatchee Trail. Court costs, and I'll be paid at least $20 a month starting August 28th.
Yes, Your Honor.
Okay. All right, what is your name?
Regina Wells.
All right, Ms. Wells, you have a new charge of petty theft. And that's from yesterday. Looks like at Walmart there on the trail. And you're already out on release, pretrial release. For a controlled substance charges and a driving while license suspended charge. Public defender will be appointed. Anything from the state or public defender on this?
Your Honor, for the 2 other charges, I think we have a conflict attorney on there.
Think you have a conflict, so you're gonna need to, you're gonna file something, or?
That's for the out on bonds. I think we have a conflict. That's what I have in my notes. But
She wasn't on pre-trial.
the petty theft, we were.
For the possession of controlled substance.
So he can only appoint us to like the petty theft. That's what I'm saying.
Okay, so I guess it just needs to be clarified to the judge what he was saying.
Your Honor.
Yes.
No, so we can be appointed to the petty theft, but there's a conflict attorney, I think, appointed to the out on bonds. That's what I have in my notes.
Yeah, he has RCC on the 2019 CT 4530.
And on the Willis?
On the CT case?
Yeah, there's a CT.
Yeah, he has RCC on the CT case.
What about the felony? It says the same. Conflict counsels on both of them.
Yes, conflict on both. RCC on both.
So we'll just go ahead and appoint them on this case.
On the new case, yeah.
What's that?
On the new case, you're gonna appoint just the PD, right?
Well, the PD's got a conflict on the new case, right?
On the out on bonds.
On the out of bond, RCC is already appointed on the out of bond.
Okay, but on the new case, the public defender's okay.
Yes, sir. Yes, Your Honor.
Okay. All right, so we'll stay the bond on the new case at $250. On the case he's out on bond, we're going to revoke and forfeit that bond, discharge it. And that's going to go to no bond. The pretrial release case will be revoked. And I'm going to set a $2,000 bond on that case. It should be the, well, let me see, which one is that? Okay, the CT is the one I revoked and went to no bond, right? That's this one. And then we put 2,000 on the other one, on the felony.
Pretrial services, does he just have one count on the felony, or is it more than one count?
It's two.
Two, so judge.
Possession of control and possession of meth.
It's what?
It's 2 counts, possession of controlled substance and possession of meth.
All right, so it'll be 2,100. Wait a minute, I'm not sure we did this right. I have your notification of revocation of pretrial release. That says he was on that she was on pretrial release on the CT case. I thought there was a bond on the CT.
What I sent over was she was on pretrial for driving while license suspended.
So he's pretrial release on the suspended license charge.
Yes,
I thought there was a surety on that paperwork. Say surety? Oh, it's a different case. No, it's a different case number.
Was the surety on the drug?
All right, on the 4530, the clerk's indicating
Yes,
they're released on bond.
that's pretrial releases form, that's where we get those forms from. They're the ones that write that form up. The out on bond form comes from their office. So they have to verify what's on those forms.
So I just want to make sure I'm reading this right. So on the 4530, they're out on that bond, right? That's what that's telling me? Free trial? Then your notification of revocation says he's on pretrial release, but this says he's out on bond. Or she.
Let me get clarification on that. That's what was sent over.
Yes, I'm reading this wrong, but wouldn't be the first. Filed it on May 1st, bond 3150.
It says no action at the top. You vote on that? Yes. Just don't print it out here, and I'll write it out here. Okay. Now go to the CT case so we can see what's going on. Just Jamaica, we're trying to look it up.
Got that switched around because the CF case is the one that I see that's released on PTR in the system. So she was released PTR on the controlled substance and meth, and she posted bond for the traffic.
Okay, so this
So
one
I'll
is,
just email her.
so that one's incorrect.
Yes.
Okay, so we can. All right, so I revoked the bond on the CT 4530.
That is on the felony case, the 2019 CF 16968. The one that you revoked as well.
Yes,
We printed the information. It only has one count.
okay, so one count.
The 2000 stands.
All right, so 2,000, and then we stayed the bond on the new charge. Public defender is appointed on the new charge, conflict counsels on the other charge. Okay, I think we figured that out. Okay, next one is David Miles.
Your Honor, have we addressed the petty theft, today's case? We
Yes.
just resolved the out on release cases.
The new
Was
charge,
there
I
a
stayed the
bond
bond.
set in the new
You
case?
talking about the last case we just did?
Yes, on Ms. Wells, on the petty theft,
Right.
retail petty theft, was there a bond set?
Yeah, I just stayed the bond. I think it was 250. whatever it
All
was.
right. Thank you.
All right, what's your name, sir?
Your Honor, I do not give my consent to being a surety in this case. I do not
Okay.
give my consent to any of the proceedings in this court.
What is your name, sir?
I'm a flesh and blood man, fully competent, of legal and lawful age, and I would like for the court to release the commercial bond so that I'll know who will indemnify me if I'm injured in here.
Okay, I'll get to that in just a minute. Is corrections there?
Yes.
What is his name?
His name is Mao, David Mao.
And that's the name of the
Okay.
the constructive trust.
Mr. Miles is there. There's a failure to appear. There's a bond set at $2,000. We'll stay that amount.
Okay.
All right, what is your name?
Jacob Rodriguez Melendez.
All right, you have several new charges here. We'll go ahead and appoint the Public Defender's Office. First of all, it indicates you're out on a surety bond in 20 CF 6432AO. And that bond's going to be revoked, and those bonds will go to no bond at this time. Your new charges of possession of methamphetamine, heroin, drug trafficking it has here, possession of a weapon by a convicted felon, and possession of drug paraphernalia. And the public defender is appointed on all those charges. Those bonds will all be stayed. And they came in at 15,000, 15,000, 200,000, 5,000, and 500. And let's see. There's some traffic charges too. Driving while license suspended, reckless, failing to register the vehicle, attaching a tag not assigned. And those bonds will be stated at 500 each. Again, public defender will be appointed. All right, is that all for him?
Did you address the out on bond?
What's that?
You revoked it.
Revoked. Yeah, with no bond. All right.
Okay.
All right, your name?
Gene Bartholomew, sir.
Okay, you have a new charge of aggravated battery. Public defender will be appointed. That bond will be stated $5,000, no contact with the victim.
I'm sorry, Your Honor. I didn't get his name.
The victim's name,
The defendant's name.
Bartholomew.
Number 2 in felony.
Smith?
No, Bartholomew.
And the listed victim is Miss Hughes, Hughes. So no contact with her. You're also not to possess any weapons. And you're out on bond on the 20 CF 7521AO. I'm going to revoke the ROR. Do you have any history on this person, State?
Yes, Your Honor. He has 29 convictions, 2 failures to appear. The last failure to appear, though, is remote. It was in 2000. His last conviction for battery on a law enforcement officer was in April 3rd, 2019. And his history consists primarily of drug charges, both felony and misdemeanor, and the battery on a law enforcement officer is and he has 2 prior batteries as well. And those are convictions, Your Honor. I did not state any of his arrest. And he has an out-of-state conviction for possession of a controlled substance.
Okay, so on your possession of cocaine, I'm going to set that bond at $5,000 as well, and 100 on the cannabis and 100 on the paraphernalia. I'm confused here. This says ROR, and it says bond amount 1,200. So was there a bond or ROR on this 2020 CF 7521?
Out on RR.
What's that?
I have out on RR.
Okay. Okay. So public defender is appointed. On the new charge, the public defender is already appointed on the old charges.
Okay, so you revoked the bonds on the out on bond case and set it at 5,100 and 100.
Correct.
Thank you.
Okay. Your name?
Ashley Coffey?
All right, you have new charges of possession of cocaine and drug paraphernalia. It's Division 11. Public defender will be appointed. You're out on bond for cocaine charges.
Yes, sir.
Any Any other history, State?
She has 3 misdemeanor convictions. Her last conviction was June 15th of 2020 for possession of drug paraphernalia. Her prior convictions were all misdemeanor drug charges, Your Honor.
All right, I'm going to revoke your surety bond on the 2020 CF 8057AO. It's going to go to no bond at this time. You can talk to the felony judge on a bond. Public defender is appointed, and I'll stay your bonds on your new charges of $1,000 and $100.
Great, thank you.
Okay, your name?
Dominique Coleman?
Coleman.
Yes, sir.
Okay, you have a new charge of, it's like an altered or counterfeit plate on the vehicle.
Can I say anything?
Ms. Coffey, this is your public defender. If there's anything about the facts that you wish to speak to your public defender that will be assigned to you. Please don't say anything in court.
Okay, thank you.
Okay, and state what history do you have?
Six convictions, 2 felony convictions, 4 misdemeanor convictions. She has only 1 failure to appear, which is very remote, 2002. Her last conviction was possession of cocaine in July of 2018. The majority of her convictions appear to be drug-related, and she has a false information conviction and no valid driver's license conviction, no out-of-state history. She's also in pretrial diversion on 2019 CF 11425AO, and that is for possession of cocaine.
Yeah, I see she's on diversion on that. This new case, the car she's driving with an altered tag. Oh, she claims she doesn't know anything about it being altered. So on the case, she's out on bond. Well, I mean, is she out on bond? She's in diversion. Or did they-
Your Honor, may the state make a recommendation as
Yes.
to the diversion case? The state would recommend that the court take no action. The new arrest could likely, she might be discharged from her diversion program anyway, but the new case could impact the out on bond or the diversion case, and it'll resolve itself.
Okay, so I'll take no action on the case she's on diversion on. That's the 19 CF 11425AO. We'll appoint the public defender on the new case. That bond is $1,000. Okay,
And Your Honor, is there a bond also on the CT case? Or is that
Yes.
not before the court today?
yeah, the failure to register the vehicle,
Yes, Your Honor.
yeah, that bond will be stated $250.
Thank you.
Uh-huh.
Wait a minute, y'all about to switch?
Okay. Bain's gonna take over, Judge Bain. All right.
Is this your name? Your name, sir?
Oh, Terrence DeTavius Garrett,
All right. Can you give your date of birth?
8/12/77.
You are here on a charge of grand theft motor vehicle. I found probable cause for the arrest in that case. I want to set your bond, or state your bond at $1,000 in order that you have no contact with the victim in that case.
Yes, sir.
You are out on bond on 2020 CF 448980 for a charge of possession of cocaine and possession of drug paraphernalia. And you're also out on bond on 2020 CF 1389AO on a charge of grand theft motor vehicle. I want to revoke and discharge those bonds. I want to set bonds at 0. In both cases. You have a good day, sir.
I call my office all the time, and it says 0. She doesn't have to post any money.
You want to say 9?
All right, no, there we go. Oh, use the terminology. Can you say your name?
Stephen William Harbison,
Mr. Harkison, can you give me your date of birth?
9/22/84.
All right, Mr. Harkison, you are here on a charge of driver while license suspended. It's an habitual traffic offender. Possession, count 2 is possession of cocaine. Count 3 is possession of methamphetamine. Count 4 is possession of drug paraphernalia. State, are you guys RR on them on these?
I'm sorry?
Are you releasing them on?
That would be,
What's your recommendation?
No, Your Honor. We would recommend ROR on cannabis,
Oh, cannabis? Okay.
misdemeanor cannabis.
if you don't mind, sir, I do have a family here.
Yep, hold on. Where you get too deep into it?
Oh, I'm sorry.
All right, Mr. Harbison, I'm going to set bond in your case. Account 1, I'm going to state a bond at $2,500. Mr. Count 2, I want to set bond at $150. As account 3, you're going to set bond at $150. As account 4, I'm going to set bond amount of $50.
All right, thank you.
Okay? Is that your name?
Denise Yard,
Can you give me your date of birth?
October 1st, 1990.
All right. Ms. Hurd, you are here on a arrest warrant, if I remember correctly, on charge of count 1, home invasion robbery, count 2, kidnapping, count 3, false imprisonment, count 4, battery. Want to stay your bonds on counts 1 and 2 at none. Want to stay your bond in count 3 at $5,000 and at count 4 at $1,000. Now, order you got no contact with the alleged victim and no return to the scene.
Well, I don't understand. I don't understand what you said, what you just said.
Ms. Hurd, you'll have no bonds as to counts 1 and 2, the home invasion robbery and the kidnapping case. You have bonds as to your other 2 counts.
Okay.
All right, you have a good day. Okay, is this your name, sir?
Charles Paul Johnson.
John, can you give me your date of birth?
I'm sorry?
Your date of birth, sir?
January 15th, 1945.
Mr. Johnson, you are here today on 7 counts. First count is trafficking in fentanyl, 4 grams or more. Second count is sale or delivery of fentanyl. Count 3 is trafficking in 28 grams or more, or less than 150 kilos of cocaine. 150 grams of cocaine. Count 4 is possession of, or with cocaine with possession of intent to sell or deliver. Count 5 is possession of methamphetamine. Count 6, possession of cannabis with intent to sell or deliver. And count 7, possession of drug paraphernalia. I want to state your bonds as set. $1,000 as $100,000 as the count 1, $15,000 as the count 2, $50,000 as the count 3, $15,000 as the count 4, $1,000 as the count 5, $1,000 as the count 6, and $500 as the count 7. You're also out on bond in 2020 CT 85080 for a charge of driver license suspended. You're also out on bond in 2020 CF 8181 on charge of possession of methamphetamine and possession of drug paraphernalia. I'm going to revoke and discharge your bonds as to those 2 cases and set your bonds at none. You have a good day, sir.
Okay. But I didn't hear what he said. I'm sorry. No, I didn't hear what he was. I didn't hear the last part what you said, Your Honor.
Yeah, what did you say, sir?
I said I didn't hear the last part of what you said.
The 2 cases that you were out on bond, I'm revoking and discharging those bonds. I'm setting your bond at none.
What? I still didn't hear.
Says your bond 0, none,
All right, so what does that mean?
no bond.
You're not bonding out today. You don't have any bonds on those cases. You have, so talk to the assigned division judge.
Good morning, Judge.
Good morning. Can you state your name?
Pablo Juarez, born in Guatemala. I'm resident in the United States now. Grew up
Okay.
in Boston, Massachusetts, in California too.
All right. Can you give me your date of birth?
10/40/1960. My social security is
Don't
015-587.
don't state that information on the record, sir.
Oh, I'm
That's
sorry.
public record.
Apologize, sir. I'm sorry.
No problem.
Apologize, sir. I'm sorry.
Today you're here on a charge of burglary of a structure while wearing a mask.
They're lying.
And
I'm
fine.
not guilty. I was there
Mr.
because
Juarez, Mr. Suarez,
Mr. Suarez,
I'm Pedro Matos, your opponent PD. Please do not talk about the facts of your case on record.
I'm bipolar schizophrenia, and they haven't given my medicine. I've been telling these people they'll be now obeying my order. The judge of Volusia, tell my wife,
Okay.
she's my guardian, and they'll give me my medicine for 2 freaking days, and I keep telling
Mr.
them.
Suarez,
Okay.
let's just get through this right now. You are
Can you explain me, please? I'm sorry.
in a
Your-
charge of grand theft. And a charge of grand theft.
I didn't steal
that's-
anything. I was there waiting
Okay.
to open the place so they can buy a car.
Okay.
I've been there.
That's
They
the
know me.
count.
The Spanish people, they know
Sir,
me already.
Mr. Suarez.
I'm sorry.
Sir, let me finish what I have to do, and then you can speak to your attorney after we're done.
Yeah.
And
I
you give
wanna-
him a call, okay?
I want to get my real attorney in Longwood.
Okay,
I got an attorney, a good one. They fired a cop for breaking my leg in Volusia County.
okay.
Good,
That's
I'm
fine.
the best.
All right.
I'm bipolar.
As the count 1 in this case, I'm gonna set your bond at $10,000. As the count 2, I'm gonna stay at $150. You also have a warrant for violation of your probation out of, I believe, is that out of Volusia County. I'll stay those bonds at none.
Okay, how can you give me 10,000 bucks when I'm telling you I'm not guilty and I'm gonna sue everyone here because they haven't given my
Mr.
medicine?
Juarez,
They
speak to your
haven't-
public defender, please.
That's what we had jury trials for, sir.
Okay. Come on. Right here.
Can you say your name, ma'am?
Autumn Mercado,
All right. Can we give you your date of birth?
June 2nd, 1990.
Oh, sorry, I have Robbie Mellon, that, he bonded?
They'll let us know. Robbie Millen.
Corrections, I have Robbie Mellon
You
next.
have a booking number for me?
Booking
Starts with 200, should be over the right-hand side of the affidavit.
I have an agency number.
Below it.
On the same line as defendant.
It starts with 2.
What's the name again? Clark?
Robbie Mellon.
Millen?
Oh, here you go. 215,664. Charge of driver's license suspended and carrying concealed firearm.
It's not a 2001?
Say again? No, those are the charges. Yeah,
Spell the last name, M-I-L-L?
M-E-L-O-N, like the fruit, melon.
First name?
Robbie, R-O-B-B-Y.
Bonded.
Bonded? All right. So it's the melon bonded. And Ms. Marcano. Ms. Marcano, can you give me your date of birth?
June 2nd, 1990.
All right, you are here on a charge of driver's license suspended as a habitual traffic offender.
Yeah. Is there any way I could get my bond reduced?
Hold on. State, do you have any history for Ms. Marcano?
Yes, however, I haven't been in trouble.
Hold on. Wait, ma'am. I'm talking to the state of Florida.
Oh.
Yes, Your Honor. She has 18 convictions, 6 felony, 12 misdemeanor. She has 3 failures to appear. Her last failure to appear was in 2016. Her convictions appear to be primarily driving and drug convictions. She has only 1 juvenile conviction and no out-of-state history.
When was her last driving case?
I don't have a date for her last driving case, Your Honor. If it was in our jurisdiction, I might be able to find it. Her last?
The last time she was here for driving was in 2015.
2015?
The last time she came here to Orange County Jail.
And the last driving history I see was in 2013.
2015.
She came here April 27th, 2015.
All right, Ms. McConnell, I'm gonna set your bond
Yes.
in the amount of $1,000.
So you're reducing it?
Yeah, reducing it to 1,000.
Thank you.
She qualifies for PTR.
They're gonna drive. That's it for Ms. McConnell.
Your Honor, am I appointed to the last case?
Ms. McConnell? Autumn, I think it was the first name.
Yeah.
Autumn McConnell was the last case.
Yeah, I'm just asking if I was appointed to it.
Public defender's appointed, I think, in all the cases.
Okay. I just wanted, since she met PTR, I was wondering if you were willing to consider that.
Not with the number of driving cases she's had. I reduced her bond. It was $2,500. I reduced it to 1,000. So it cost her $100 to bond out. So
That was all, Your Honor.
You got anything? Yes, it's good.
Can you state your name, sir?
Jason Perez.
All right, Mr. Perez, you're here for failure to register as a sex offender. Your bond in the state of $1,000. Judges have previously found probable cause for your arrest. I'm going to stay your bond at $1,000. You're also out on bond in 2020 CF 6804AO. Sorry, you're out on PTR.
Judge, that's what that form is for.
That's right.
That's for the out on bond.
Okay, I see.
You already signed it, so whatever you decide you're gonna do, then you write it
I'm just
on.
gonna, revoke it. I'm gonna revoke your pretrial release as the 2020 CF 6804AO. And you'll be held in that case at no bond.
Yes, it's just they, because it's pre-trial release. Mr. Perez?
No, prejudice. Can you state your name?
Joshua Priest.
All right, can you, John?
Joshua Priest.
Joshua Priest, okay. Can you give me your date of birth?
3/12/91.
Mr. Prince, you are here on 6 counts and on 3 different charging affidavits and case numbers. In 2020 CF 8495AO, you're being charged with 2 counts of grand theft motor vehicle. On 2020 CF 8496AO, you've been charged with burglary of a conveyance and petty theft. And 2020 CF 8497AO, you've been arrested on a charge of burglary of a dwelling and criminal mischief.
Is it just burglary of a dwelling?
Yep, and criminal mischief.
It's not burglary of an occupied dwelling?
It is burglary of an occupied dwelling. The law doesn't really make a distinction anymore of the different charges. As to 2020 CF 8495, did find probable cause in that case. Gonna stay your bonds on $1,000 on each count. On 2020 CF 8496AO, I'm gonna stay your bonds at $3,500 as the count 1 and $250 as the count 2. On 2020 CF 8497AO, I want to stay your bonds on count 1, the burglary of the occupied dwelling, $5,000, and $500 is the criminal mischief. During your arrest, you were out on bond, out on ROR, in 2019 CF 16893AO. I got a question for. If she says ROR, but then I see a bond surety here, the information.
Yeah, I have out on bond over here.
Sorry, okay, so you're out on bond, I just want to make sure. As to that case, I'm gonna revoke and discharge your bond. I'm gonna set a new bond in that case at none. All right, you have a good day, sir.
Your Honor,
Yes, sir.
Rivera Costa, he refused
sir.
court.
I'm going to appoint Mr. Rivera Costa, I'm going to appoint a public defender to represent him. Mr. Public Defender, what would you like to do with Mr. Rivera Costa?
Can we reset, Your Honor?
All right, want to reset him for tomorrow? No, it's not, this is, that's all felony. It's all in charge of the felony.
So we reset them for tomorrow.
Yeah, reach out for a while. Is this Mr. Juan Roland?
Yes, sir.
All right. Can you give me your name?
Juan Alexander Roland.
All right, Mr. Roland, you are here on a charge of felony battery. I did review the charging affidavit in this case and did find probable cause for that charge. I want to set bond in your case in the amount of $202,500 with pretrial release conditions, that you have no contact with the victim, you not return to the scene of the location, you are to not possess any weapons or firearms, including a common pocket knife.
Understood.
Good. Yes, sir? That's it.
All right, thank you.
Have a good day, sir.
And that's bond.
It's bond and PTR.
What was the bond?
Bond is $2,500 with pretrial release conditions.
I could barely see it.
Is that your name?
Roderick Smith.
All right. Smith, you're here on two cases. We'll deal with the first case, 20 CF 8485 AO, threatening a public servant. I've read the charging affidavit in this case. I do find probable cause. On set your bond in that matter at $2,000. You're also arrested on a warrant for aggravated assault. I don't have a case number. Yes, I do. I'm sorry. I apologize. 2020 CF 7847 AO. Judge has previously found probable cause for your arrest in that case. They set the bond at none at this moment. But I'll set your bond in that amount, in that case, an amount of $10,000. In order that you have no contact with the victim in that case.
Yes, sir. Can I ask you a question if you don't mind?
Yes, sir. If it's about the facts of your case, I suggest you talk to your public defender that's been appointed to represent you in both your cases.
I don't think it's like nothing that serious though, sir. It's just like at the end of the day, like the aggravated assault with a firearm.
Mr. Rowland, this is your PD. When it comes to any of the facts of this case, please speak to the PD assigned to you in the downtown office.
Yes, sir. I understand. It's
Anything
not
here will be used
nothing
against you.
incriminating. I just wanted to ask a question.
Okay, good.
Because my like this charge, I don't feel like I was, treated right. Because my uncle that wrote the statement, he just
Mr.
knows that
Rowland.
I'm a CWP holder, and he just falsified a statement for you guys just to get me messed up. And I don't think
Mr.
that's
Rowland, you're speaking on the case.
So that's a defense that you can talk to your attorney about, and he can raise a jury trial or with the attorney or any other kind of proceeding that preceded the case. Okay?
okay. So one more question. So would this hinder my CWP license?
I can't give you any legal advice. Your attorney can probably let you know, and if the department gets wind of it, they'll send you a notice to let you know if your license is still good or suspended.
Yes, sir.
Okay?
One more, and look, I thought the that one for the threaten the public law servant, I thought that was only $1,000 bond.
Yeah. I'm saying
Yeah,
bond
but-
is $2,000.
Yeah, you upped it, right?
Yes,
Yeah, y'all put it to 2,000.
correct.
Okay, thank you so much, sir.
All right. You have a good day, sir.
Thank you, have a nice one, appreciate it.
Your Honor, next on the list is White.
Yes,
He's
sir.
in the hospital.
All right, we'll reset him for tomorrow.
Judge, do we reset them within 24 hours release from hospital? Because we don't know.
Whatever,
when.
however you guys, I mean,
Okay.
sometimes that's how you guys want to do
So I
it.
won't reset it for tomorrow, reset it within 24 hours of release.
Reset it for 24 hours release.
Thank you.
I'll appoint the public defender to represent him. Pay all his bonds at none right now. We have some out-of-county warrants. Can you state your name?
Jarwan Parker.
Mr. Parker, you're here for an arrest on an out-of-county warrant in Seminole County.
But I had
Looks
the
like-
warrant. I had the warrant forever, but I don't been in jail a couple times, and I'm trying to figure out where the warrant popped up from because I never even been associated with stuff like this. Like, you know, so that's what I'm trying to figure out.
I don't know. Looks like there's a, yeah, what's your date of birth?
1/14/91.
Looks like there was a warrant, for human trafficking, for a judge in Seminole County.
But when was the warrant issued? Because like I came to 33rd probably like a month ago. And I did 6 months here, and I still did. They saying this from 2018, and I'm just like this just popping up, and I did 6 months in county jail, and this never popped up. I'm sorry.
I'm not sure, sir. I can't tell you. Only information I have, because I didn't write the warrant, I didn't sign the warrant, so I don't, only thing I know is that they're in the database. It says that there's a warrant for your arrest for that charge. And,
But you know
you
when
can
the
talk to your public defender here.
But did you know when it was issued? Because I'm lost on the fact of when it was issued. They wouldn't tell
Does
me.
not state in the information I have right now.
That's what I'm saying. They're not giving me no information on when this warrant was issued. And
Well, the public defender has been appointed to represent you while you're here in the Orange County Jail. So try to give them a call, and they'll try to work out whatever happened, whatever the warrant needed to be recalled and never got recalled or something like that. They can figure that out for you. Right now, you're going to be held on no bond until Seminole County comes to pick you up.
And how long is
They're
that going
not
to be?
transporting, so what we do is when court is done, I email these to the JA and she contacts the other county.
Yeah, so we should have some information for you soon to contact your attorney to be able to give you information, okay?
So I can't get a bond on the out of county warrant because they're not, like, I can't get a bond on it?
I don't know when this is before, after, I can't.
Oh, so you wanna take no
That's what I'm saying, because this case, they said it's from 2018. If I'm out on the bond already, this is way before that time.
Yeah.
So I should be able to get it.
Yeah, I'm not taking any action on your cases that you have bonds.
No, that's what I'm saying. This is way before this even happened. So
I
there's,
understand that. That's the reason why I'm not taking any action on your other cases. Your other cases are still intact. You still have bonds in those cases.
okay, so I can't get a bond for my out of county warrant because if
I
that's
can't give you a bond as to a court I don't have jurisdiction over. So Seminole County is in a different jurisdiction because of how our constitution is set up. So we are in the 9th Circuit. I can't give you any cases on the 13th Circuit out there in Seminole County.
So how long?
Okay.
How long have they got to come get me? How long have they got to come get me before like this can be resolved?
Yeah, sir, you are in a quandary of a lot of other people in our state. We are doing some cross county things. That's why I said you need to talk to your public defender and like explain what's going on with
them. They don't have a time limit to come and get me because I'm sitting here being held in jail with no information on why I'm being held in jail. That's what I'm saying. They not giving me no information on why they arrested me for this case. They not giving me no information on nothing. Like they not helping me at all. Ain't nobody giving me nothing. Like nobody give me no information. Try not to give me no bond on this case. They gave me no reason who the heck this human trafficking is behind. This is the 2018 case. Like none of this makes no sense to me at all. None of this makes no sense. It doesn't make no sense. That don't make no sense. And like I don't see people coming here and get bonds on out of county warrants, and I can't get a bond on something that you guys can't even give me no information on.
Mr. Parker.
It's okay. I understand.
Like that's like, come on, like y'all can at least try to help me. Like ain't nobody y'all can try to help me. Like come on now, I don't see people get bonds on out of county warrants, and I'm trying to sit and say I can't get a bond on an out of county warrant. That's not fair. That's not fair. Y'all not giving me no information on what is going on.
Listen to me what I'm trying to tell you. Let me explain to you. Right now, because of COVID, we're under a state of emergency. Our governor has issued executive orders stating so. All right, which included and we're limiting the amount of transfers of people from place to place. Because of the charge you're being faced with, which is a first-degree felony, and charged in certain ways is a life felony, where you can spend the rest of your life in prison.
Exactly. That's what I'm trying to tell you for somebody.
I can't give you a bond, which is part of the order, the executive order, and the order from the Florida Supreme Court. So right now, what I need you to do, I know you're upset. I understand that, this is a really frustrating time, but I need you to work with your attorney to help figure what's going on out. I can't give you any legal advice. Only thing I can do is what's in front of me, okay?
So if I get in contact with Seminole County and they can give me a bond on this case, I can bond out through here.
Yep. So your attorney can contact your PD in Seminole County or get the public defender's office appointed to your case out there in Seminole County. They can work with the judge out there to figure out if their warrant was valid and if the warrant, you can get a bond for that warrant, okay?
Because I don't really think that.
Right now, today, I can't do those things to help you. I just need you to talk to your public defender, and he or she will help you resolve the case.
Got no information. Like y'all don't got nothing on me for me to be in this case. I don't like this.
Paul is the last person. Paul.
You have a booking number, Your Honor.
You don't have a Paul on the docket, Your Honor.
Paul? Yeah, I have Marvin Paul.
Inmate number again.
I have a
200-1-3440. That's 14340. They already get transported to, where was he? Looks like Alachua.
I don't know why it's not here. It says that he should be here.
They hit him with some magic dust. Make him disappear.
He's not coming up in your system.
We have two separate groups. The first I have showing that is here is Mr. Hamstra, James Hamstra.
Good morning.
Morning, Mr. Hamstra.
Good morning.
Second, find you. You don't have the affidavit? It's not filed in the court file? Is that an IA? All right, thanks. Mr. Hamster, I'm looking at your initial appearance paperwork in 20 CF 1889. This case deals with 2020 CF 1127. Looks like Judge Sanders Morency found a on-view violation in 20 CF 1129, which is our case based on the allegations in 20 CF 1889. I'm going to accept a denial as to that allegation at this point. We're going to appoint the Office of the Public Defender to represent your interest. I'm going to give you a new set of court dates in front of Judge Wooten.
Okay.
Is that our case, or is that in front of Judge Wooten? Oh, okay. It's going to be in front of me, so we'll give you a new violation of probation date in front of me. All right, your attorney's going to be out to talk to you about what your options are. We'll see you on July 29th, if not before.
Okay, thank you.
Thanks. Jesse Jennings.
Nicole Dupre on behalf of Mr. Jennings.
Thank you. Morning, Mr. Jennings.
Morning.
Mr. Jennings, I'm holding the affidavit from your probation officer. It's in 2019 CF 4015, indicates an allegation that you have violated Condition 3 and Condition 5 of your probation. One is by leaving Polk County without the consent of your probation officer, and the other allegations are the new law offense issue that you have in Columbia County. We're going to accept a denial as to the allegations in the violation of probation. We are going to appoint the Office of the Public Defender, while they're already appointed, to represent your interests. I'm going to give you the same VOP court dates that you just heard, and your attorney's going to be out to talk to you about what your options are, okay?
All right, thank you.
Yes, sir. Hold on. All right, thank you.
Your Honor, what was the status date again?
7/29, Ms. Adams.
Oh, so like the day before the hearing. Okay.
Yep. All right, thanks.
Thank you.
Bye. Anastasio Maragildo Surratt.
Your Honor, he's going to need an interpreter.
Okay, thank you.
Good morning, Your Honor. This is Alan Figueroa, State Certified Spanish Code Interpreter.
Good morning, Mr. Figueroa. Have you been sworn yet this morning?
Yes, Your Honor.
We have with us Anastasio Maragildo Surratt, and he is at the jail facility. You will be interpreting over our PA system. The case number is 2020 CF 1633. Good morning, sir.
Buenos días, señor.
Sir, can you hear me?
Señor, ¿me escucha? Yes.
Sir, you were arrested and charged by information in this case with 3 counts.
Señor, usted fue arrestado y fue acusado de 3 cargos en este caso.
The counts allege criminal mischief with damage of more than $200 to a place of worship.
El primer cargo es de causar daños a propiedad ajena de más de $200 a un lugar en un lugar de alabanza.
Count 2 is burglary of a structure.
El segundo es de entrada ilícita con fines delictivos de una estructura.
Count 3 is resisting an officer without violence.
Y el tercero es por desobediencia a la autoridad.
Those are alleged to have occurred on June 7, 2020.
Eso se alega de que ocurrió el 7 de junio del 2020.
I will appoint the Office of the Public Defender to represent your interests.
Se le designará a la oficina del defensor público para que lo represente.
Mr. Tagdiri, do we have an offer of resolution on this?
¿Hay alguna oferta en este caso, licenciado?
Okay. State of Florida is indicating they do not have an offer of resolution at this time.
La fiscalía ha indicado que no tienen una oferta para resolver el caso en este momento.
We're going to accept a plea of not guilty as to these allegations.
Así que asentaremos declaración de inocente en este momento ante estos alegatos.
I'm going to appoint, I've already appointed an attorney to represent you.
Ya se le ha designado un abogado para que lo represente.
We'll announce a new set of court dates.
Le daremos nuevas fechas de comparecencia.
Your attorney, I'm sorry.
I was just going to ask you if you could please repeat it because I couldn't hear the clerk.
Of course.
Pre-trial date of September 30th, trial date of October 12th.
Fecha de vista probatoria el 30 de septiembre y el 2 de octubre para fecha de juicio.
Your attorney will be out to talk to you about what your options are.
Su abogado irá a verlo para hablar sobre cuáles pueden ser sus alternativas.
Thank you, sir.
Gracias, señor. Your Honor, if the interpreter could get the last name of the defendant again.
Of course. Last name was Meregildo, Meregildo-Sarat.
Thank you, Your Honor.
And we may have one additional case. Who's representing Gonzalez Moss?
Nicole DePray on behalf of Mr. Gonzalez Moss.
Thanks. Does Mr. Gonzalez Moss need the assistance of an interpreter?
I'm not sure, Your Honor. I have not been able to speak to Mr. Gonzalez Moss as of yet. I've tried to schedule visitations with him, and they've been canceled. I was able to override it yesterday with the assistance of IT technician in the jail, and I have one scheduled for the 16th. So I'd like to reset the plea in order for me to confer with my client.
Are you Mr. Gonzalez Moss?
Yes, sir.
All right, thanks. Do you need the assistance of an interpreter?
No, sir.
All right, thank you for your assistance.
Not a problem, Your Honor.
All right, Mr. Gonzalez Moss, you're, I think you were just in from Lake County. Your attorney's been making efforts to meet with you and has been unsuccessful. Is that on your end, or did you know anything?
I've been up the road. I've been in prison, and they've been canceling every visit.
I'm sorry, I didn't hear you.
I said I'm on DOC custody, so
Okay.
I ain't be able to talk to her.
Okay. All right, so you were able to make an appointment, and we think we have that sorted out?
Yes, Your Honor. I contacted the jail yesterday, and they overrode whatever was occurring, and they gave me an appointment for the 16th at 10:30 a.m.
7/16. All right, she's going to be talking to you on 7/16 at 10. We're going to set you for next Wednesday before me. If you wish to resolve your case, we can resolve it then.
Yes, sir.
All right.
Thank you.
Okay, Mr. Gonzalez Moss's case will be reset for a plea on July 22nd at 8:45. All right, I think that leaves only Mr. Colon Vasquez. That's not set until 9:30. So, corrections, if Mr. Colon Vasquez could go back or stand by and we could get the second group of our arraignment folks, I'd appreciate it.
Yes, sir, Your Honor.
All right, thank you. We're going to switch over now to our live courtroom.
Is that it for the jail feed? And then no quarantine.
Ms. Chris or Mr. Prey, do we have colleagues over in our alternate courtroom?
We do. Miss Ortega is over there.
Thanks. All right, good morning, courtroom 4A. Can you hear us? Thank you, Ms. Ortega. All right, we have a number of cases this morning set for arraignment. If you are here for arraignment, the court's role in this process will be to simply advise you as to the allegations that have been formally charged against you, to talk about getting an attorney on board if they are not already on board, and to give you a new set of court dates off in the future. Is Jean Balzo Rivera present? Is there a Balzo Rivera present? Okay, thank you. Thank you very much, Deputy. All right, the court had issued an order to appear for a violation of probation to Mr. Balzo Rivera. It appears that there had been no violations and that Mr. Balzo Rivera had gotten behind in some costs at the request of the probation officer. Probation officer was asking that the probation be revoked and terminated, and to simply place the court costs in a civil lien. We'll let the state digest that particular recommendation, make a determination whether they want to move forward with the violation of probation hearing. I'm going to reset.
Judge, the state would be following that recommendation.
All right, thank you. Okay, in the absence of Mr. Balzo Rivera, the court is going to are we dismissing, or we can't revoke and terminate without a without an admission? Appears the allegations are $360 in costs of supervision and $521 in court costs. So either it'd be a dismissal or the court can reset.
We can reset it, Judge.
All right. Thanks. The court's going to we're just going to give this a violation of probation status state, 729, and I'll ask that Mr. Balzo Rivera be renoticed for that date. Thank you. We'll take no action on the failure to appear. Leonard Lanham. Good morning, Mr. Lanham. Mr. Lanham, you were charged by this charging document, which I'm holding. It's called an information. Charges 1 count, grand theft, 3rd degree, for something alleged to have happened on June 3rd, 2020. Have you had an opportunity to fill out an application for the services of an attorney? All right. Thank you. It's being delivered to me as we speak. Thanks. Right, it appears that you do qualify based on your sworn responses. Court will appoint the Office of the Public Defender to represent your interests. Is there an offer of resolution, Mr. Taggier?
Yes, Your Honor. The offer would be an adjudication, 18 months, supervised probation, impulse control class, no return to the scene, no contact with the co-defendant, court cost, cost of prosecution.
Thanks. That's something that you're interested in. We can resolve that today, but it would come with an adjudication. If you'd rather talk over your case with your newly appointed attorney, that's fine as well, and I'll give you some court dates in the future. Sounds reasonable to me. We'll accept a plea of not guilty at this time. You can always change your mind, and we're going to give you a new set of court dates in the future. Yes, sir.
Trial date of September 30th, trial date of October 12th.
All right, thank you, sir. We'll give you those court dates in writing. Minerva Morgan. Morning, Mr. Kelly. Good morning, Ms. Morgan. Ms. Morgan, we're going to place you under oath.
Please raise your right hand. Do you solemnly swear or affirm that the testimony you're about to enter into this case is the truth, the whole truth, and nothing but the truth, so help you God?
Thanks. Mr. Tagdieri, are you doing this one?
Yes. Yeah.
All right,
I'll tell you
thanks.
what to say. I also have a copy of the score sheet.
Thank you. All right, Mr. Kelly, I don't have a plea form. What are we doing this morning? Yes, sir. All right, thank you. Has Ms. Morgan had an opportunity to go over a plea form? All right, thanks. We'll have one of the court deputies, I guess, if you. Yes, ma'am. Thank you. All right, Ms. Morgan, you have been sworn. You've heard the representations of your attorney. A score sheet is being delivered to the court. Appears that there are no prior criminal offenses. I want to go over some of the rights that are contained on that form. Did you have an opportunity to read and go over that plea form with Mr. Kelly? Did you understand everything on it? You understand that you have a right to have a jury trial as to this allegation. At the jury trial, the state of Florida would have to prove to a jury beyond and to the exclusion of every reasonable doubt you committed each element of every offense that you were charged with. At that trial, Mr. Kelly would have been with you. He would have cross-examined the witnesses and examined the evidence against you. You would have had a right to present your own witnesses and your own evidence. If your witnesses had not wanted to come to court, could have asked me to make them come to court with a subpoena. You could have testified or remained silent and not testified. That would have been your decision after you talked things over with Mr. Kelly. Thanks. And your attorney would, and your jury would have been instructed not to consider your decision to remain silent in any way in rendering a verdict. You would have had a right to have the trial recorded and appeal any error that occurred in that process. Do you understand you're giving up all of your trial rights because if I accept this plea, I'm going to go along with this resolution that you are agreeing to and we're not going to be having a trial. You understand all that? Is anyone forcing you or pressuring you into making this decision? Has anyone made you any promises other than what's written on your plea form? Are you under the influence of any alcohol, drugs, or mental issues that cause you not to understand the decision that you're making? You understand if you are not a United States citizen, entry of this plea would subject you to deportation. And if you ever before have been convicted of a sexually violent or sexually motivated offense, entry of this plea could subject you to involuntary civil commitment. Do you understand that? Mr. Kelly, is the defense stipulating a factual basis for purposes of the plea? Court accepts that stipulation, finds that Ms. Morgan appears to be alert, intelligent. She's had an opportunity to think about this decision and discuss it with Mr. Kelly. Are you satisfied with Mr. Kelly's services? Seems like he's worked you out a good deal on the withhold, and you've indicated to me no one has forced you or pressured you into making this decision. You do so of your own free will. Court's going to accept your plea of no contest to one count of obtaining public assistance by fraud, a third-degree felony allegation. The court will withhold adjudication. Going to be sentenced to 5 years of supervised probation. As a condition of that probation, you're going to do 100 hours of community service. That's to be done at a minimum rate of no less than 5 hours each and every month, starting 30 days from today's date and every month thereafter until those hours are complete. You can do more than the 5 hours, but that's the minimum. You are agreeing not to petition for any public assistance for a period of 12 months. You are agreeing to restitution, the amount of $35,144 to repay for the food stamps. Where's that go? Anybody know? Okay, all right. You'll pay that to your probation officer, and they will get the restitution where it goes. You're also agreeing to $33,932.14 restitution for the Medicaid benefits. State of Florida will not object to a request of early termination of your probation if all terms are completed and there's been no violations and you're all paid up with the restitution. You're going to need to report to your probation officer within, well, you need to report by 3 o'clock today. We'll give you some paperwork to report. Have I missed any of the terms of the plea, Mr. Tegner?
That's everything.
Mr. Kelly? You're going to have 30 days from today's date to appeal the judgment and sentence to the court. If you wish to do so, you must do it in writing. If you can't afford an attorney, one will be appointed for you. We're going to get some fingerprints before you leave the courtroom. We'll give you some paperwork to check in with probation. Good luck to you, ma'am. Thank you. Oh, I'm sorry. There's some court costs that you're going to owe.
$410 of court costs, $3 team court fee, $100 cost of prosecution. To the court fees total is $513.
I'll just require that those court costs be paid off within your probationary period, so you have 5 years to pay those. The court costs, and I think that'll do it for you. Good luck, Ms. Morgan. Thanks, Mr. Kelly. See you. Right, Jarwan Parker. Is there a Mr. Parker present? Thank you, Deputy. Thank you, Deputy. All right, on Mr. Parker's case, the court does notice that we sent out notice for today's date. We sent notice to both the defendant and the bondsman Mike Snap bail bonds. That was for 6/22. The court found a failure to appear when Mr. Parker did not appear and found a waiver of speedy trial. We reset the arraignment for today. I don't see notice went out. Amy, can you see that it went out? All right, we've got no return mail at this point for Mr. Parker's case. Bail bondsman was again noticed for today's date. We called the hallways. Mr. Parker is not present. The court's going to issue a warrant for Mr. Parker's arrest, revoke his previous bond. The court will set bond in the amount of $3,500 as to count one, and $1,000 as to count two. $3,500. We'll make it $500 as to count two. And speedy trial has previously been read. So Ortega, any other folks in courtroom 4 Alpha? Oh, okay. Ashley Arroyo, if you'll come on up to the podium, please. Good morning, Ms. Arroyo. Let me find your face. All right, Ms. Arroyo, you are before the court based on an allegation of violating your probation in 2019 CF 2767. The allegation is a violation of Condition 7, a positive test. You're already represented by the Office of the Public Defender. State, is there any offer of resolution on this one?
Judge, the offer is 11 months in the Osceola County Jail.
I think we're safe to accept a denial as to the allegations at this time. Let you talk that your options over with your newly appointed attorney, and we're going to give you a new set of court dates.
DOP status of July 29th.
So definitely reach out to your attorney as soon as possible. Go over the options. We'll see you back on the 29th. All right, I'm showing that that does it for our in-person 8:45 and 9 o'clock docket. All right, we're going to switch back over to the jail feed. Thank you. Good morning, Osceola County. Good morning, sir. All right, some of you are here for arraignment this morning. Arraignment's a opportunity where I formally advise you of the charges against you. We'll talk about getting an attorney on board, and then we will talk about some court dates in the future. Anthony Barham present.
How you doing, Your Honor?
Good morning. Is it Barham or Barham?
Barham.
Barham. Mr. Barham, you are in custody based on an allegation that you violated probation in 2019, CF 3741. The allegation is a new law offense that is alleged to have occurred on July 9th, 2020, and leaving your approved residence without prior approval. That's a allegation of a violation 13. And there's a second violation of condition 13 being out of place on 6/24. The violation of condition 9 by failing to comply with all instructions, violation of condition 13 on 6/25, and a violation of condition 9 for the 6/25 out of place. I'm going to appoint the Office of the Public Defender to represent your interest, Mr. Barham. We're going to accept a denial as to the allegations at this point, give you a chance to talk things over with your newly appointed attorney, and I'm going to give you a VOP status date.
Okay.
VOP status of July 29th, VOP hearing of July 30th.
Mr. Barham, we'll see you on the 29th, if not before.
Okay.
Thank you. Kevin Gilliard.
Pasha Tagir on behalf of the state.
Nelly Ortega on behalf of Mr. Gilliard.
Thank you. Morning, Mr. Gilliard.
Hey, how you doing?
Not bad, thank you. Mr. Gilliard, I'm holding information, which is the charging document. It alleges in 2020 CF 1576, 3 counts, count 1 for you, count 2 on the information, would be burglary of a dwelling. The second count would be criminal mischief with damage of $1,000 or more. And count 4 would be resisting an officer without violence for something alleged to have happened on June 18th. That's right, 2000. I'm sorry. I don't have the date. I think it's May 28th, 2020. I'm going to appoint the Office of the Public Defender to represent your interests. We're going to accept a plea of not guilty as to these second and third degree felony allegations, as well as the misdemeanor. And we're going to give you a new set of court dates.
And Judge, could we transfer that to Division 101? There was a co-defendant information filed on 20 CF 1590, Orlando Rosario. There's 4 defendants. They're all filed on one information. So if we can transfer that to Judge Morgan.
All right. Okay. It appears that the lowest case number is in front of Judge Morgan. The court's going to approve the Ore Tennis request to transfer this case to Division 101. Mr. Gilliard, you're going to be in front of Judge Morgan. And do we have Judge Morgan's dates? We're going to try and find Judge Morgan's dates for you, Mr. Gilliard. All right. Your pretrial is going to be on August 12th. Your trial period will begin August 24th. Your attorney is going to be out to talk to you about what your options are. And If the case is able to be resolved, they'll get you in front of Judge Morgan well before then, okay? You understand all that? Thanks. Thank you, sir. All right, do we have Tammy Taylor?
Good morning, Your Honor.
Good morning, Ms. Taylor.
Kelly Crisler on behalf of Mr. Taylor.
All right, thanks. We have Ms. Demers joining us by video chat. We also have a witness waiting in the lobby. I'm going to admit that witness at this point.
Okay.
Good morning, this is Keith Carson. Can you hear us?
Yes, I sure can.
All right, thank you. And your name, sir? Ma'am?
Joseph C-A-N-C, C-I-A-N-C-I.
All right, thank you, Mr. Cianci. Present is Ms. Taylor by the video feed from the Osceola County Jail. We also have the Assistant State Attorney, Ms. Demers, joining us on this feed, and Ms. Crisler is here in open court with me. We are set for a status hearing today. The court had previously signed an order transferring Ms. Taylor to State Hospital. Based on the COVID protocols, Ms. Taylor remains in the Osceola County Jail and has not been transported. Creates somewhat of a situation for Department of Children and Families. They are requesting the court consider release pending transfer. Ms. Demers, what is the state's position as to that request?
The state would object at this time. We have held a competency hearing. We've heard testimony from 2 doctors. The court ultimately found that commitment to the department and state hospital is best for competency restoration. Previously, Ms. Taylor did actually leave the state of Florida. I believe that was December or January, and was actually picked up in Tennessee. It had to be extradited back down here when she was on conditional release. I'm sympathetic and I understand the complications due to the COVID protocols, but at this time, based on the court's order, I don't know how we get her to state hospital any faster, but I think at this point, conditional release would not be appropriate.
Ms. Crisler?
Yes, Your Honor. Given all of the COVID protocols and everything, Miss Taylor's health is at risk. She does have a multitude of medical issues, which we have gone over before in court, including an issue with her heart and various other ailments as well. In a conversation with the caseworker, Ms. Dickerson, she did request that she be placed on conditional release under the supervision of Ms. Dickerson. And at this point, Your Honor, I understand the state's position, but we would be asking for that.
Your Honor, can Ms. Crisler clarify who is Ms. Dickerson, and is she with the Department of Children and Families, or is that through the Public Defender's Office?
Yes, Ms. Dickerson is the social worker that coordinates transportation and which beds are available for the Department of Children and Families. She is their caseworker. She works with them. I believe yes, that's where she works. She is not associated with the Public Defender's Office.
Thank you for clarifying.
All right. The status quo in Ms. Taylor's case is not acceptable. Ms. Taylor's in the Osceola County Jail, and the court is convinced that that is not the best place for Ms. Taylor based on the findings and recommendations of the doctor. At no fault of her own, she's in need of competency restoration and treatment and is unable to receive that treatment based on the state of Florida's unwillingness to accept new patients and transport. I am going to consider a conditional release plan. I'm going to ask that the defense and the state reach out to this representative from the Department of Children and Families and come up with a written conditional release plan that addresses her mental health concerns in this interim. If the state requests sworn testimony from Ms. Dickerson, then the court can accommodate that sworn testimony by video or by affidavit.
Yes, Your Honor.
I am going to reset this for next week, next Wednesday at 8:45. Ms. Taylor, by next Wednesday at 8:45, I am going to consider recommendations for your release if the state of Florida can't figure out how to get you to the state hospital. And I think that would be, under these circumstances, the most appropriate consideration. But I do want to give the state a little bit more time to see if they can work out a plan with the defense that satisfies their concerns. So we'll see you next Wednesday, and at that point, either you will have been transported or I will consider reasonable conditions of your release.
Yes, sir.
All right.
I really appreciate it, Your Honor.
Yes, ma'am.
Okay.
We won't forget about you, I promise.
Okay, please don't, and if it's not decided to go ahead and transport me, will I be released on conditions to my husband and Miss Dickerson, and to appropriately do those guidelines that are suggested from pretrial, from Miss Dickerson, Your Honor? I promise, with all that I have in my heart, I need to go to get better at the hospital for my physical conditions, but my mental, I'm taking all 4 medications. I'm feeling great. My clarity is there. My judgment is much, much better. And Your Honor, the only reason I left the state was to take care of my sister, who is a dying alcoholic, was to get her to
Miss
sleep.
Taylor?
Okay.
Miss Taylor?
Yes.
I'll be in touch, okay?
Oh, Kelly, don't forget about me, please.
I won't.
Okay?
We've got
God
you.
bless.
We've got you on our docket for next week, and
Okay,
she's going to be
please
working
don't
on it.
forget about me, okay?
I won't.
We'll
Okay,
see
Your Honor, thank you,
All
folks.
you next Wednesday. Thank you.
All right, good day.
And Your Honor, I will speak with Ms. Chrysler about everything that's going on, but I would anticipate at this point likely wanting to take some sworn testimony from Ms. Dickerson, just so for scheduling purposes and stuff that's out there.
No problem. If you'll reach out to Ms. Hafner if you need 15 or 20 minutes on this one next week, I'm happy to accommodate.
Yes, Your Honor.
Thank you.
Thanks.
Hello?
Hello, sir. We're gonna readdress this case next Wednesday at 8:45, and the state and the defense are gonna be working on what they feel are reasonable conditions of release, and then I'll make a decision next week.
Okay, Your Honor, am I allowed to say anything?
We don't need to take testimony today. I encourage you to join us next week when I'm actually making some decisions with some recommendations. I have received your correspondence and read it.
And one thing, Your Honor, is that who will be contacting me? I don't use numbers that I have, do I?
Joseph, we'll speak, okay? This is Lauren. Me and Lisa will give you a call and we'll fill you in on next week's proceeding, okay?
That would be fine. Thank you very much. And thank you, Your Honor.
Yes, sir. Thanks for joining us.
Thank you.
I'm going to disconnect now.
You're welcome.
All right. Shamika Sloan.
Good morning.
Good morning. Give me just a moment.
No problem.
All right, thank you, Ms. Sloan. The court received some correspondence from you on July 7th, 2020. It made an allegation that you were requesting a new attorney, and the court has set today's proceedings for something called a Nelson hearing.
Right, yes, sir.
At a Nelson hearing, you don't need to speak in legal terms. You just need to let me know what is going on. Your attorney will have an opportunity to respond should they choose to do so. We're going to place you under oath at this point.
Okay.
Please raise your right hand. Do you solemnly swear or affirm that the testimony you're about to enter into this case is the truth, the whole truth, and nothing but the truth, so help you God?
Yes, ma'am.
Ms. Sloan, when you're ready, tell me what's going on.
All right. Actually, I talked to my attorney yesterday, and I don't even feel the same way as I did before. I just felt like she didn't want to listen to anything that I was saying to her. And, but after I talked to her yesterday, I feel like she did hear me, and she understands, and she does want to, resolve this.
All right, thank you for that information, Ms. Sloan. So what I can take away from that is, at this point, your request for a Nelson hearing, you'd be withdrawing that. Is that correct?
Right, yes, sir, please.
Okay, no problem at all. And Ms. Broadway will continue to represent your interests. As you have seen, you can correspond with the court if you have concerns, and the court will address those. So we're going to go ahead and cancel today's hearing, and I thank you for joining us. Is there anything?
Thank you. I'm sorry, Miss Broadway.
Your Honor, we are also here for a plea date. I have reached out to Ms. Merced, factually where we were, the plea agreement. I don't know if Ms. Merced's in the lobby.
Let me take a look. Yeah, Mr. Tagdarius.
Procedurally, the state wanted to have Ms. Sloan agree to a condition to testify truthfully and consistently with a previous statement she made in December. The problem was that that statement has two different versions, one in which she denies any allegations and the other in which she admits portions of the alleged crime here. Because there's two different versions, having a condition in the plea that indicates you testify consistently to two inconsistent statements becomes a problem for the defense. Ms. Merced at that date did not want to go forward with the plea. She wanted to set a proffer. That was 2 weeks ago. I've sent 3 emails to Ms. Merced asking how she wants to schedule this. I'm available. I've received no response. So today we are set for a plea. I don't know where we stand in resetting this case at this point because I haven't heard anything, so I don't know if Mr. Tagdiri has any information for defense counsel or the court.
Is this plea contemplating a probationary sentence that would effectuate a release?
It would be, no, it would not be her release.
Okay.
Ms. Merced emailed me last night about this case. She said it would need to get reset because she does want to set up the proffer. I'll reach out to her and tell her to reach out to Ms. Broadway.
Right. Proffer needs to happen by next Wednesday at 8:45. I'm going to bring back Ms. Sloan if she wishes to resolve her case.
I mean, I can acquire Ms. Sloan. Do you still want to accept the offer?
Yeah, if that's the best I can do, absolutely.
Okay.
I do.
At this time, what we'll do, Judge, is if the court will give us a reset date, I don't know how Ms. Merced would like to do the proffer. I would ask for 2 weeks, Your Honor, just based on scheduling. I don't know if the court would be okay with that.
Yeah, that's fine.
And Ms. Sloan, I'll reach out to you in the interim.
Right, yes, ma'am.
That puts us into a pretrial and DOP week, so why don't we do the following week? So we're going to put it on for August 5th at 8:45.
Thank you, Your Honor.
All right, Ms. Sloan, your attorney's working hard for you. We'll see you back on August 5th if not before.
All right, thank you.
All right, thanks. Ms. Broadway, which was your other case?
Your Honor, that was the 10:30, Maribeli Velasquez, the bond hearing.
All right, I'm not quite there yet. About Mark Vasquez. We have Mr. Vasquez. Good morning, sir.
Melly Ortega on behalf of Mr. Mark Anthony Vasquez.
Good morning, sir. All right, I went back through the court record on Mr. Vasquez's case. Mr. Vasquez was set for a competency hearing on April 17th. I didn't see any notes from that date. Ms. Ortega, did that not occur?
Your Honor, that's correct. That did not occur, and today I set it for a status. I did provide the clerks with the updated report from Dr. Duros. It was a confidential evaluation. It did come back competent. I've already provided it to the state.
Okay, thank you. And as of February 5th, the defense was not stipulating to the findings of Dr. Pittman. What are you requesting this morning, Mr. Ortega?
Your Honor, I would just be submitting the report by Dr. Duros into evidence and stipulating to it.
All right, thank you. Anything further from the state?
This is Lauren Day's case.
Is she joining us by video, or do we have?
She should be joined by video.
Okay, let me see if I can find her.
Your Honor, when I did set this status, the ASA on it was Andrew Bain. Since then, it's changed to Ms. Day, I guess.
Okay, I don't see that set for any of our. Let's see if she's in the agenda. So this would be a stipulation to competence, is that correct?
That is correct, Your Honor.
And say we stipulate to that, Judge.
All right, as to Mr. Vasquez's two cases in 2018 CF 3640 and 2018 CF 4265, based on the stipulation of the defense and the state, the court will consider the evaluation of Dr. Duros and her recommendations contained within the report. The court will find Mr. Vasquez to be competent to proceed at this time, and the court will place him on a pretrial and trial date.
Pre-trial date of September 30th, trial date of October 12th.
Mr. Vasquez, Attorney Ms. Ortega will be talking to you prior to those dates about what your options are. We'll see you on those dates, if not before.
Okay.
Thank you, sir.
Your Honor, are we ready to bring back in Mr. Cologne?
Yes, please. Thank you.
One moment, please.
Thanks. All right, for the attorneys on the Cologne Vasquez case, he's going to be brought in just a moment, so we'll be in a brief recess. Right, good morning. You are Mr. Colon Vasquez?
Yes, Your Honor.
All right, thank you. We'll call the case 2020 CF 1621, Edwin Colon Vasquez, representing the state, please.
Danielle Pinnell on behalf of the state.
Thank you, Ms. Pinnell. And representing the defense.
Good morning, Your Honor. My name is Julio Gil de la Madrid.
I'm sorry, I missed.
Gil de la Madrid, Your Honor.
Thank you, sir.
And
I'll be appearing as co-counsel. I haven't filed my notice, but that came in as of late. For the record, Jose Rodriguez, I know you know me, Judge. And I've already spoken with the state. We'll be doing that in short order of notice, Judge.
All right, thank you. Okay, the court is handling a hearing for Judge Wooten, I understand. And this is a motion requesting the immediate release of the defendant and/or motion to set reasonable bond and/or motion requesting an Arthur hearing. Counsel, you want to break that down into pieces?
yes, Your Honor.
All right, thank you.
Yeah, I think we filed the motion on Monday. Basically, my client has been incarcerated solely on the order of an arrest order of the state of Florida that was obtained on June 2nd, and he was arrested on June 10th. And he's been incarcerated today, 36 days. According to the rules, Your Honor, the prosecutor had 30 days to file criminal charges. No criminal charges has been filed as of yet. And based on that rule, we're requesting immediate release. Nevertheless, Your Honor, in the alternative, we are requesting a reasonable bond be set in this case. Even though the arrest warrant, he's arrested for a first-degree murder case, Your Honor. If we review the arrest affidavit by Agent Sostre, there is no evidence in that arresting affidavit of any premeditation. There is no evidence of malice. The only thing that one of the witnesses, Charlene, states that there was an argument, that she was present at the time of the argument. There was two people arguing, and one of the persons shot the other person. So that would be a manslaughter case. That would never be a first-degree murder case, Your Honor. Either way, these facts occurred in a party at 3, 4 o'clock in the morning. It was a reggaeton party where there was alcohol and drugs, and everybody in that party was either drunk or high on substance. They're alleging that my client arrived there much later than the party started. And we have, according to the incident report, Your Honor, and according to the affidavits, the arrest affidavits, the same establishes an alibi for my client. You know, the arrest, the incident report, which was presented as an exhibit, Your Honor, indicates that the time of the occurrence of was at 4:35, 4:36 in the morning. According to the affidavits submitted to obtain an arrest warrant, the arrest warrant doesn't place my client at the party, but does establish that he was in the vicinity. And he left that vicinity at 3:51 in the morning. And then when they was rechecked my client's phone, he was at his house at 4:17. So if the alleged murder occurred at 4:35, well, my client was not there, according to the affidavit by the agents. And you know, there's a witness that indicates that apparently they saw my client was the one that fired the gun, but there is no murder weapon as of today. The only thing that they found was, I think, casing, and I'm sure that the casing does not have the fingerprints of my client. So, you know, in order to deny bail, Your Honor, the case law is very clear, and the Arthur case is very clear, Your Honor. The prosecutor has to state a degree of proof that requires, that's beyond reasonable doubt or any doubt, Your Honor. And the case says beyond any questions of doubt. Obviously, this is not the case in order to deny bond, Your Honor. And all the case laws that are established on page 9 through 13 of our motion, Your Honor, clearly establish that proof the prosecutor does not have. The mere fact that they're overcharging in the arrest affidavit does not establish that our client, that is beyond question of doubt, which is a level of evidence superior to reasonable doubt, Your Honor, according to the Supreme Court of Florida. For that reason, Your Honor, we understand that he's entitled to bond, a reasonable bond, Your Honor. Not only that, there are 4 witnesses that the defense have that clearly contradicts the witnesses of the prosecution. 4 witnesses that were not high or they were not drunk, you know, totally different from the witnesses. And the alleged owner of the home didn't identify my client, according to the affidavit, didn't identify my client until 23 days later. That day she was detained, she was taken to the sheriff's office, and there apparently, you know, they let her sleep it off for, I think it was 24 hours or whatever. And she just gave a version. 23 days later, apparently she gave a statement saying that it was my client, Your Honor. But there are no scientific evidence to link my client to that. There's no DNA, there's no fingerprints, and the only thing they have is that witness statement. Furthermore, Your Honor, my client, obviously, with the affidavit alone, of the arresting affidavit alone, clearly establishes that the prosecutor does not have that heavy weight to require that this court not to give bond, Your Honor. Basically, you know, I have 4 witnesses that can testify, and they're out in the hallway with regards to the character of my client. You know, he has never been arrested. We have a certificate here, which I failed to present to the court, but from the Florida Department of where it states he has no criminal record here in Florida. He's been here, living here for basically 9 years. He's been working. He's the president of a corporation that's an institute which is associated or a branch of the corporations of Puerto Rico, which are 6 corporations, 6 schools, technical schools. He's the head of that school, and basically he's the brain of the school, Your Honor. This is a business that produces over $21 million a year, and you know, my client has not been convicted of any crime as an adult or as a minor, Your Honor. And to think that he would kill someone that he doesn't even know and shoot somebody he doesn't even know, you know, I think that's very questionable. But either way, Your Honor, the burden of proof is not there for the prosecutor to request that my client be held without bond, Your Honor. I submit it, Your Honor.
All right, thank you. Ms. Pinnell, the first request is a automatic release pursuant to Rule 3.134. Is the defendant entitled to that relief?
No, Your Honor. According to the Supreme Court Order 20-23, the Supreme Court specifically talks about persons arrested, not charged, arrested with first-degree murder. The timeline in Rule 3.134 is specifically addressed, and it is suspended at this time. At the time of the defendant's arrest, it was suspended, and at this point, it's suspended until at least July 26th, according to the order. although we anticipate that due to the inability of convening a grand jury, it's going to be further suspended. That rule also applies to any request for a adversary preliminary hearing, which part of the defense counsel argument seems to be as to the probable cause that was already previously found in the warrant. So as to the defendant's request for release ROR, I believe that is in direct contradiction with the Supreme Court order.
Court agrees with the state. The relief requested in pursuant to Rule 3.134 has been specifically addressed by the Supreme Court in AOSC 20-23 Amendment 5, indicating that that relief is suspended at the very least until the 26th of July. The court does anticipate that that will be extended, but the request for automatic release on his own recognizance is denied. As to the entitlement to an Arthur hearing, Ms. Pinnell, is the state moving forward with a attempt to show proof is evident, presumption is great?
Yes, Your Honor.
All right, thank you. Do you have witnesses or evidence?
Yes, Your Honor. First, I'm going to approach defense counsel. This has been marked stage 8 for identification. This one case here that I'd like to check the history.
Your Honor, can we have a minute to review this? Because we just got it.
This wasn't provided as part of the...
No, I spoke to the counsel yesterday, and she didn't mention that she had this and she was going to present it. And it's 2 pages long.
Okay.
Your Honor, I was present this morning. I did briefly speak to defense counsel outside. I did not previously provide the document.
Do you have additional exhibits?
No, Your Honor.
This is the only exhibit? All right. Thank you. All right, sir, if I can have you just have a seat in the front row there, and your attorneys are reviewing some documentation. So you don't need to stand at the podium. Thank you. Corrections, do we have anybody else that's present?
We have another group that has to come in, Your Honor, separate from him.
I see.
I can get Demetrius Cox up if you're ready for him.
Yeah, that's going to be another lengthy hearing as well. We had some other hearings, Lopez, Cancella.
He's in Polk County, Your Honor.
Okay, well, I guess we could address that one. Okay, let me address Lopez Cancella. Is Mr. Costner present?
No, I can. It'll be just a minute. I can get him up here though.
Oh, I thought you said he was in.
No. He can come in with this group. I just didn't bring him up because he was scheduled for 10:45.
Oh, we have him. Lopez Cancella is. Yeah, we got him at 10. How about Dwayne Brown, and
Velasquez,
And
yeah, they're all a
Velasquez.
separate group.
They're all a separate group. Okay.
Yes, sir.
Okay,
And Joel Ayala, he's also in that same group.
okay, so they can't be together. All
No,
right.
sir.
But we can get Mr. Lopez Cancela up?
He's in Polk County.
He's in Polk County.
Yes, sir.
All right, thanks. Is Mr. Costner present? Okay, we're gonna call 2020 CF 1811 Lopez Cancela. It was set for what it was set for? Status, I guess. Let's see, Mr. Costner is appearing by video, so let's.
Good morning.
All right, good morning. We're on the record 2020 CF 1811 on Mr. Lopez Cancela. I understand he is still in Polk County?
Yes, Your Honor, he is.
Okay. All right, thanks. I see that this was set for a bond hearing today. Is there anything that we can get accomplished with him being not located in the county?
Your Honor, I'm hoping that the court, we can just set bonds on him for the, whatever the standard bonds are. At this time, Polk County is unwilling to do a bond hearing for him because he is an out-of-county case. They are unwilling to transport him because of COVID, and it's my understanding that the Osceola County Jail is unwilling to accept him even if Polk would transport him. So he's stuck being held, at least at this point, at 19 days, no bond allowed, on a case that frankly I can't even see in the clerk's website yet, because I don't even think Polk has sent the information over to Osceola, letting them know that the warrant was served. So I mean, we're at something has to be done.
I understand the dilemma, Mr. Costner. Mr. Merce, was the victim notified of our hearing today?
Yes, she was, Your Honor. My victim advocate has been in touch with her. She did not wish to be present today, but she was made aware. This is kind of a similar situation to what Your Honor and I had another case like this yesterday.
Correct.
I just want to make sure that if we are proceeding to set bond in these matters, defense is waiving his client's right to be here under the circumstances, and as long as, you know, I think at this point he's entitled to bond as far as I can tell. He does have a pending Polk County case that he was arrested on. It's sort of out of the same incident, but it is different charges. So we do have two separate incidences with the same victim, but he does have pending charges in Polk County for false imprisonment, battery by strangulation, and resisting without violence. I didn't have a chance to send the score sheet over, but he has minimal history outside of these cases. I see a possession of cannabis where he did PTE in Polk County, and then a no valid driver's license from 2018. But I do believe he would be entitled to bond at this juncture.
All right, thank you. The court's obvious concern is giving alleged victims an opportunity to participate in a critical stage. Based on the representations of the state of Florida, the victim in this case has been given that opportunity and declined to participate, which is perfectly within their rights to do. The court finds that Mr. Lopez Cancela is entitled to bond as to each and every count, and with a minimal criminal history, the court would be inclined to impose a no contact without having any input from the victim in this case. As to bond amounts, Mr. Merce, does the state wish to be heard?
Not as to specific bond amounts, Your Honor. I think setting it according to the bond schedule would be appropriate, and then I would ask for the standard domestic violence conditions: no contact, no return, no weapons. I do believe there is an injunction in place or a temper that's been served. So
there is a temporary injunction. Your Honor, as far as the no return, I don't know the allegations in this case because frankly, again, I haven't seen the warrant. I haven't seen anything other than what Polk County has. I know that the address listed in the Polk County case is where my client resides, not where the victim resides. But that address is also in Polk County, although it is a Kissimmee address. Again, I don't know where this case occurred.
Okay.
I just, that's all I have right
All right. Mr. Costner, are you,
Sorry.
yeah, I'm sorry to interrupt. Are you waiving Mr. Lopez's Cancella's appearance for purposes of this hearing?
Yes, Your Honor, I would be.
All right. Based on the unique circumstances in the COVID protocols, the court's going to accept that waiver. Ms. Demers, can you give me an address? Was this alleged to have occurred where these two cohabitate, or?
Your Honor, this, and I don't know if Mr. Costner has a copy of the injunction. It is the same address that's listed on the injunction. This occurred at a relative's house. If Your Honor, give me just one moment, I can pull up the exact address that's listed.
Okay.
Actually, they were in Polk County and an incident occurred there. They came into Kissimmee to a relative's house. An incident happened here, and then they went back to Polk County. That's kind of how it all went down. For purposes of the no return, it's going to be
Injunction I have.
Madrid Drive.
Okay. All right, the court's, based on that information, is going to set the following bonds. As to count one, bond's going to be set in the amount of $500. As to count two, bond will be set in the amount of $1,500. As to count three, bond will be set in the amount of $1,500. As conditions of those bonds, Mr. Lopez Cancella is to have no contact whatsoever with the alleged victim, either in person, through third parties, or electronically. He's not to return to 637 Madrid Drive, Kissimmee, Florida. He is to possess no weapons or firearms. He is to consume no alcohol and to possess or consume no illegal substances. Any other conditions of bond requested by the state?
No, Your Honor.
Mr. Costner, anything further?
No, Your Honor. I would just ask if somebody could make sure the Polk County Jail gets a copy of this order. I'll send an order once it's available to me, but I know they're not going to accept it from me.
Right.
If the state or the court can fax a copy over, that would be greatly appreciated.
All right. Do we have the ability to? I don't know who to send it to, Mr. Costner. So if you want to give us some contact information, we can send it directly from here. Yeah. So you're going to get the copy of the court minutes ordered emailed to you right after court today. And if Polk County won't listen to you, send it. Let Ms. Hafner know, and we'll send it from our office.
Okay, perfect. I appreciate it, Judge.
Not a problem. All right. Anything further on this hearing?
Nothing from me, Your Honor.
Thank you. That'll conclude our hearing.
Right, thank you.
Yes, sir.
Thank you.
All right, let's circle back to our hearing in progress. Hey, officer. Any updates for me, officer? No?
Sir.
Okay, all right. All right, we're back on Colon Vasquez. This is 2020 CF 1621. Has defense had an opportunity to take a look at the documents provided this morning?
Yes, Your Honor.
All right, thanks. Are we ready to proceed?
Yes, Your Honor.
Thank you. Ms. Pinnell?
If I may, is that the only witness the state is planning to present trust threat, or are there other witnesses?
I'm just calling to check the social.
Well, when he's done, I'd like to invoke the rule because we have witnesses as well, Judge.
All right.
So we'd like to invoke the rules when he's done.
Okay.
We've already instructed our witnesses.
All right, the rule of sequestration has been requested in Mr. Colon Vasquez's case. If you are a witness here on that case and are not the state's first witness, if you'll please remain in the hallway, our deputies will call you when it is time to testify, and please do not discuss the facts of the case with anyone or each other pending your testimony before the court. Ms. Pennell, you may call your first witness.
Your Honor, before I call my first witness, I would seek to introduce in evidence what's been marked States A for identification, and the evidence is States 1. I'm sorry, the defense counsel made a couple marks on this. I don't have another clean copy.
All right, is it just underlines or is there notations? Objections?
Your Honor, as of now, we object because it's totally hearsay, and the witness has not established that that document was prepared by him, and I didn't see any signature in the document.
Well,
I'm sorry, Your Honor.
That's all right, we're having difficulty.
Sorry. We would object at this time to be admitted because it's hearsay evidence, Your Honor. We don't know if Mr. Soster was the one that prepared that document. I didn't see any signatures on that document. So, Your Honor, I would object to being hearsay at this time, Your Honor.
Thanks, Ms. Pennell.
There is a signature on the last page of the document indicating that Detective Sostre swears that all the facts are sworn to is true in that affidavit. Affidavits that are sworn are admissible in these types of proceedings.
All right, thanks. The court's going to overrule the objection pursuant to the case law. The court can consider affidavits. And let me take a look at the document. As to authenticity, the objection is overruled. The court finds that the document appears to be what it purports to be, and as the gatekeeper of admissible evidence, the court finds it to be authentic. It will be considered over defense objection and come in as States 1 for purposes of this hearing only. May I call your witness?
The state would call Detective Louis Sostre.
Morning, Detective.
Morning, sir.
Do you solemnly swear or affirm that the testimony you're about to enter into this case is the truth, the whole truth, and nothing but the truth, so help you God?
I do.
May the witness stay at the podium or?
Yes, he's welcome to be at the podium or in the witness stand, if that's probably better for acoustics if he's up there in the witness stand with us.
Good morning. Will you please state your first and last name and spell your last name for the record?
Good morning, ma'am. Louis Sostre, S-O-S-T-R-E,
Where are you employed?
Osceola County Sheriff's Office.
How long have you been at the sheriff's office?
15 years.
What's your current assignment at the sheriff's office?
Plotting Crimes Unit,
How long have you been assigned to that unit?
3 years.
As part of that unit, do you investigate homicide cases?
Yes, ma'am.
Did you respond to 2650 Hilliard Court in Kissimmee on May 10th of this year?
Yes, ma'am.
What's the purpose of you responding to that address?
It was a call out in reference to a homicide.
Was it in the early morning hours of May 10th?
Yes, ma'am.
When you arrived on scene, were there witnesses still on scene when you got there?
Yes.
And was the victim still on scene when you arrived?
No.
When you arrived, did you go into the residence?
Yes.
What did you see in the residence?
I saw a garage that was converted into music room. I saw the scene where there was blood on the floor, alcohol bottles everywhere. Saw a casing.
You said that you saw blood on the floor. Was it a significant amount of blood?
Yes.
And the casing, where was the casing that you saw in relation to the blood?
The casing was located in the middle of the room, which would have been probably about 6 feet from where the blood was.
Is this a small room or a large room?
It's a small room.
And was there a projectile also recovered from the room?
Yes, ma'am.
Now, crime scene technicians arrived on scene, and they're the ones that actually collected the evidence in this case, right?
Yes.
And they were able to collect the projectile?
Yes.
And did you see any other evidence of any other shots being fired? Did you see any other projectiles, any other casings, anything like that?
No, ma'am.
And you indicated that the witnesses were still on scene. Did you make contact with somebody named Charlene Castro Rojas?
Yes, ma'am.
And she, in fact, is the homeowner or resides at this home, right?
Correct.
And can you describe her demeanor when you first saw her?
I would describe her, she was distraught.
What makes you describe her? What was she doing?
She was physically shaken. She was talking very, very fast. And she would lose her train of thought as we were talking.
Did she have any blood on her?
Yes.
And did you talk to her about that?
Yes.
And Ms. Rojas, Castro Rojas, provided you a sworn statement on that night?
That morning, yes.
And did she tell you what her relationship was to the victim?
Yes.
What was her relationship?
They were friends.
Did she describe it as close friends, distant friends?
She described them as a very, very close friend.
And did she tell you how close she was at the time that the victim was shot?
Yes.
How close was she?
She was standing right next to him.
And how did she tell you that she got the blood on her?
She explained to me that once he was on the floor, she had tried to stop the bleeding.
Hearsay is admissible, Your Honor.
Court's going to consider the hearsay at a bond hearing. You may continue. Objections overruled.
So she said that she tried to stop the bleeding, and she was holding him.
And ultimately, she contacted 911 after the shooting as well.
Correct.
Your Honor, objection. We have been patient, but just the counsel's leading the witness with all her questions.
Objection is leading. Sustained. Ask your question, Mr. Pino.
Do you know who called 911?
Yes.
Who?
Ms. Castro.
And did Ms. Castro appear to be forthcoming the night of the shooting?
No.
Did you later talk to her?
Yes.
What was she telling you on the night of the shooting?
On the night of the shooting, she was telling me that she was at the party. It was her party. She invited some friends. Unexpected or uninvited people showed up. She got into some words with those individuals. One of the individuals shot her friend, and they left.
Okay. Now, did she tell you that she was aware of who these individuals were initially?
No.
And later on, did you conduct a follow-up interview?
Yes.
And was Ms. Castro more forthcoming during the second interview?
Objection, Your Honor. She's also leading the witness, Your Honor, and she's trying to establish a fact that's not in evidence, that she's been truthful. We don't know if she was ever truthful, Your Honor.
As to leading, overruled. As to suggesting the truthfulness of a witness, the court will give it the weight it thinks is necessary. The objection is overruled. You may continue, Ms. Pino.
Did Ms. Castro provide you more information the second time you spoke to her?
Yes.
Did she tell you why?
Yes.
What did she tell you?
She said she she was in fear.
Did she elaborate?
Yes.
What'd she tell you?
She was in fear because she knew, or she found out and knew about the suspects, the contacts that he had, how connected he was, the amount of money he had, how affluent his family was
Where?
in Puerto Rico.
Where is Ms. Castro from?
Puerto Rico,
Does she have family that resides in Puerto Rico?
yes.
And I know you said that she was in fear. Did she express exactly what she was afraid of?
She used the word retaliation.
But ultimately, she decided to provide you with more information.
Yes.
It's still leading. Sustain.
What other information did Ms. Castro provide you?
She ultimately identified the shooter, which was a suspect. That was the biggest information she gave us.
Did she also identify the other individuals that Mr. Colon was present with?
Yes.
Were you able to ascertain how Ms. Castro knew who Mr. Edwin Colon Vasquez was?
Yes.
How?
She explained while living in Puerto Rico, Mr. Colon Vasquez was on the news. He was dating a beauty pageant, so she became familiar with them through social media.
Once she was in Florida, did she have acquaintance with Mr. Colon Vasquez?
She did say yes.
Now, did she specifically identify what role Mr. Colon Vasquez had in the shooting, and what was that?
She identified him as the shooter.
Did she explain to you how the shooting happened?
Yes.
What did she say?
Well, she said that they were at the party. She initially saw individuals she didn't invite. There were some words exchanged. Things stopped, calmed down. Words were exchanged again. She was confronted by two individuals, one being Mr. Colon. As the words being exchanged, our victim stood up to defend her. At that point, he was shot in the face.
Did any of the witnesses describe a physical altercation that occurred between the defendant and the victim?
No.
Now, Ms. Castro Rojas was not the only witness on scene.
Correct.
Did you also make contact with somebody identified to you later as Alan Tubin?
Yes.
Did you make contact with him on the night of the shooting as well?
Yes.
What did Mr. Tubin initially tell you?
He initially said that he was smoking a cigarette. He heard he felt what was a bang. So he doesn't recall hearing a bang. He recalls looking up. And pretty much that was it.
Was Mr. Tubin forthcoming with you, the initial contact you had?
No.
Objection, Your Honor. Going to the state of mind of another witness.
Sustain.
Did you get a lot of information from Mr. Tubin?
No.
I'm still leading, Your Honor. We've been sitting here and keeps leading and leading and leading.
As to that question, overruled.
Did you meet with Mr. Tubin on a different date?
Yes.
What did Mr. Tubin tell you?
He ended up at that time saying pretty much the same things he said the first time. He was outside smoking a cigarette. He felt what he thought was a bang because his ears were ringing. He said he looked up. As he looked up, he saw Mr. Cologne with the gun in his hand, and at that same time saying that no one's going to leave the room.
Was Mr. Cologne speaking English or Spanish?
Spanish.
Where is Mr. Tubin from?
Puerto Rico.
Do you know when Mr. Tubin arrived in Florida?
Yes.
When?
January of this year.
Do you know if Mr. Tubin has family in Puerto Rico?
Yes.
Who does he have in Puerto Rico?
His mother and a younger sister.
What did Mr. Tubin tell you as to why he had additional information?
He said he was in fear. Actually, he broke down crying. He was in total fear of retaliation and that something was going to happen to his family.
Did Mr. Tubin advise you of his relationship with Mr. Colon Vasquez?
Yes.
What was it?
They became friends once he moved here. They were both in the music industry, and with that connection, they became friends.
Did Mr. Tubin also know the other individuals that were present with Mr. Colon Vasquez?
Yes.
And was he able to identify them to you?
Yes.
Finally, did you speak with somebody named Eddie Morales?
Yes.
Going back to Mr. Tubin, did you swear him in prior to taking both of his statements?
Yes.
Mr. Morales, did you swear him in?
Yes.
What did Mr. Morales tell you initially?
Initially, that at the time of the incident, he was outside purchasing the Uber Eats that he had ordered. And prior to him coming back into the house, he was told he had to leave, so he left.
Did you have a further conversation with Mr. Morales?
Yes.
Did he relay any additional information?
Yes.
What was it?
He said that he was actually in the house. He had gotten the Uber Eats, went in the house. He was sitting in a chair eating his McNuggets. And at that time, he says he saw our victim speaking with Mr. Cologne and a couple, he said it looked cordial. He says the next thing he knows, the victim falls at his feet.
Were you advised of any relationship between Mr. Morales and Mr. Colon Vasquez?
Yes.
What were you advised?
I was told that they were friends, had met in Puerto Rico, and Mr. Morales was friends with Mr. Cologne's girlfriend.
Now, there was a DJ at the party,
Yes.
and did you identify that individual as Simeon Roman?
Yes.
Did Mr. Roman tell you why he was at the party?
Yes.
What did he tell you?
He was hired to play the music for the party.
Now, what did he tell you regarding the incident that occurred?
Actually, what he stated was that he was playing his music, he heard the bang, looked up, saw Mr. Cologne holding a gun and saying, "No one's going to leave this room."
On May 10th, when you were talking and seeing and speaking with the witnesses, were you advised of any intoxicants they might have taken?
Yes.
Start with Ms. Castro.
On the night of the first interview, she had admitted to alcohol being consumed.
Any illegal substances?
At that time, no.
Later on, did Ms. Castro admit to taking illegal substances?
Yes.
What did Ms. Castro tell you in regards to how the cocaine got to the party?
She admitted that she had asked Mr. Tubin if he knew anyone who had cocaine or marijuana. He in turn contacted someone.
Who did he contact?
His friend Carlos.
Did his friend Carlos arrive at the party?
Yes.
Who did Mr. Carlos Lamb arrive with?
Mr. Cologne, individual they were calling JB, and Mr. Echeverria.
All of the witnesses that you talked to, were they all sworn in?
Yes.
I have no further questions.
Thank you. Counsel, cross-examination. The court?
Mr. Sotres, good morning.
Good morning, sir. How are you?
Good, thank you. Okay, Mr. Sotres. At what time you arrived at Charlene's home on May 10th?
After 6 in the morning.
After 6 in the morning? And at what time was the 911 call?
4:35 in the morning.
Would 436-27 be more accurate?
No, 4:35.
Okay. marked the incident report into evidence, Your Honor. I asked the prosecutor, she said she had no objection.
All right, thank you. That will be received as defense 1. We need to have that marked, please. If you'll approach the clerk.
Thank you, Your Honor.
Is that more than one Fabian was showing? I believe this is attached to the bond motion.
All right. Thank you. Be received as defense 1 for purposes of this hearing. Of course.
Is that the incident report, Your?
Yes.
Yes. What time does it say that it was reported?
The one you have highlighted?
Yes.
0435 and 0436.
That's when the incident occurred. The one towards your left.
Oh, so 436.
436, it was, that's when they received the call. And what time did the person say that the incident occurred? According to the report.
Which person are you speaking about?
The person that called 911, you said it was Charlene.
Okay. So what was your question? I'm sorry.
At what time did the report states?
Says between 435 and 436? I'm not understanding what you're asking.
Okay.
That's what the report says.
And isn't it true that that night you knew the name of Edwin Colon? They informed you who was Edwin Colon?
That morning, yes.
Yes, that morning. And isn't it a fact that from May 10th through June 6th, you never visited the house of Edwin Colon?
Objection, relevance?
Overruled.
The day of the search warrant was the first time, and that was on June 5th.
On June 5th. You also knew where Edwin Colon worked?
Yes.
You didn't go to his work?
Excuse me, Your Honor.
Yes.
He can't be heard. He's not talking into the podium.
Yeah.
Oh, I'm sorry. I'm sorry.
There we go. Thank you.
Yes, sir.
Sir, isn't it a fact that you never went to the place of business where Mr. Colon works?
Correct.
Correct. So you never interviewed Mr. Colon?
Correct.
And the 3 persons that were with Mr. Colon, you did not interview them either?
Correct.
Okay. But you did do a search on Mr. Colon's telephone?
Yes.
Okay, and you did that when?
I could not tell you the exact date.
Was it on May 10th, same day?
No.
No. Okay, but you did do a search on his phone, travel search?
Yes.
Yes. And you put that in your arrest affidavit?
Yes.
Yes. And you failed to mention that fact in the affidavit that was marked Exhibit A from the government?
Which facts?
The facts that you investigated his phone, his whereabouts through the phone?
Correct.
Correct. And if Your Honor, I would request the court to take notice of the affidavit that's, I think is marked Exhibit 3. I don't have a clean copy to show. Mark as evidence. I have a highlighted copy.
It's attached as an exhibit to your,
Yes, it's attached to Exhibit 3,
this is the affidavit?
the affidavit, the arrest affidavit.
Right. What are you asking the court to do with this document?
I wanted to mark it as a Exhibit 2.
Judge, I don't have any objection to it being considered by the court for purposes of this hearing.
All right, thanks. Court's going to hand over my copy of the affidavit. We'll mark that as Defense 2 without objection. Of course. Of course.
Sir, is that your arrest, the affidavit for arrest warrant?
Yes, sir.
Okay. And in your affidavit for arrest warrant, I would draw that question. While you were at the scene on May 10th, did you take notes?
Yes.
When you took the persons to, did you preserve those notes?
Yes.
Did you take notes when you were interviewing at the sheriff's office?
Objection relevant?
No rule.
I don't think so.
You don't think so? When you interview Charlene Castros the second time, did you do so at her house or at the sheriff's office? Or you don't
The
remember?
sheriff's office.
Sheriff's office. Did you take notes that day?
No.
No. And isn't it a fact that on May 10th, Ms. Castro Rojas did not tell you that the shooter was Edwin Colon?
Correct.
Correct. Isn't it a fact that Mr. Tubin didn't tell you that Castro Colon, that Colon Vasquez was the shooter that night, that day?
Correct.
Correct. Okay. And in your arrest affidavits, go to page, first of all, you recognize as your, I think actually the question, affidavits for arrest warrant?
Yes, sir.
Okay, go to page 2. Paragraph 6, we established, it starts with cell.
Okay.
Okay. That paragraph is not in the Exhibit A of the report that the prosecutor presented, right?
Correct.
Correct. And that paragraph A is a reconstruction that you as a police officer made of the cell phone where Mr. Colon Vasquez's cell phone was located on May 10th.
No.
No? And what was the purpose of doing this investigation?
Are you asking me
Yes. Paragraph 6.
the cell site? I don't reconstruct it.
You didn't reconstruct it?
I don't do it personally, no.
Okay. But in your affidavit, it says that when it was reconstructed, you say that at 3 o'clock, 3:07 in the morning, Mr. Vasquez's phone number was traveling to the area of 2650. Does that report?
Your Honor, I'm going to object to defense counsel reading the affidavit into evidence. It's in evidence and the court can read it.
Is that a question, counsel? Is that a
Yes, Your Honor.
question of this witness? Objection is overruled. You may ask your next question.
Okay. Is it a fact that according to your investigation, at 3:07 in the morning, Mr. Vaca's cell phone was registered near the house where the alleged murder occurred?
Yes, sir.
Okay. And isn't it a fact that according to your investigation, at 3:51 in the morning, the cell phone left the area where the victim was murdered?
Yes, sir.
Yes, sir. And according to Exhibit 1, the incident occurred at 4:35, 4:36 in the morning.
That's the time it was reported.
No. Can you go back to Exhibit 1? What time does it say that the incident occurred?
Reported?
Yeah,
It was
no,
reported?
reported on the other side.
Occurred between 04:35 hours and 04:36 hours.
Okay, that's when the alleged murder occurred.
Objection, Your Honor. That is when the report indicates that the offense happened. That's not necessarily when the offense happened.
Objection is overruled. The detective can answer that if he knows. And ask your question again, counsel.
The reports indicate that the incident occurred at 4:35 something in the morning.
That's what the report says, but that is not actually,
I'm asking what the report says.
the report says yes,
Okay.
04:35.
And at that time, according to the reconstruction of his cell phone, of Mr. Vasquez's cell phone, and your affidavits, at 3:51, Mr. Colon Vasquez was not at the home where the murder occurred.
It remained until 03:51 hours, yes.
And you went even further. You investigated where was his phone at 4:17,
Yes.
and where was it located?
It was near the residence at 5407 Simpson Road, which is his residence.
At his residence. Okay. And when you interview Mr. Tubin on May 10th, he also did mention that Mr. Colon was the shooter.
I'm sorry, can you repeat your question again?
On May 10th, you interviewed Mr. Tubin.
Correct.
And that day, he did not tell you that that Mr. Colon Vasquez was the person that did the shooting.
Correct.
Correct. He told you that he didn't see who was shooting, right?
Correct.
Right. And he did not mention that he saw a gun in Mr. Colon Vasquez's hand.
Yes, you're right.
And the same applies to Miss Charlene Castro Rojas. She did not inform you that Mr. Colon was the shooter.
Correct.
And she did not inform you that Mr. Colon had a gun.
Correct.
Did you interview Mr. Carlos Sanchez?
Objection asked and answered.
No, sir.
Did you interview the person that they called John?
No, sir.
No. Did you interview the person that was called JB?
No, sir.
Is there a reason why you didn't interview them?
Yes.
You indicated that in Exhibit A, that there was no confrontation between the victim and Mr. Colon Vasquez. Is that what you stated?
Correct.
And in your arrest affidavit, you stated that there was a confrontation.
Yes.
And that paragraph of the arrest affidavit, which is the fifth paragraph, there you do not state which of the two individuals were arguing.
The fifth paragraph, can you tell me which fifth paragraph you're talking about?
The one that starts with the homeowner, Charlene Castro Rojas. On page 1.
Oh, on page 1, I'm sorry. Okay, yes, I see it. I'm sorry, so what was your question?
It does not state there that one of the two individuals that they were arguing with was Colon Vasquez.
Correct.
But you have no evidence to establish that prior to that night, May 10th, or the early morning hours of May 10th, Mr. Colon Sanchez and the victim knew each other.
Correct.
You have no evidence to establish that there was a grudge between them prior to that party.
Correct.
You have no evidence to establish any type of relation, money relation, music, or schooling relation with the victim, Mr. Colon.
I'm sorry, correct.
On the contrary, everyone told you that Mr. Colon Vasquez and the victim did not know each other.
Objection, asked and answered.
In several occasions, I didn't finish the question.
Overruled.
They informed that in several occasions.
Correct.
Right. And going back to the time frame for the cell phone, after 4:17 in the morning, Mr. Colon's cell phone remained at the house, at his house.
Correct.
Did you take as evidence Charlene Castro Rojas' her clothes?
I believe evidence did, yes.
Okay. Was she swabbed for gunpowder residue?
No.
Was any of the three witnesses that you interviewed that day were swabbed for gunpowder residue?
No.
No. Were they tested for drugs?
No.
No. Then you indicated that days later, you interviewed Miss Charlene Castro Rojas, and she's giving you a different version of the facts.
I wouldn't say different, I would say additional information.
Additional information. Information very important, like the shooter.
Yes.
And she informed you that she didn't come forward before because she was afraid.
Correct.
She never told you that Mr. Colon Vasquez communicated with her and threatened her, right?
No.
She never told you anybody threatened her.
No.
So her threat was a speculation on her part.
I would say yes.
Yes. And Mr. Subit, you interviewed him for a second time.
Yes.
Did you keep notes for that interview?
It's the second time, I don't recall.
Were any of these interviews recorded?
Yes, sir.
They were all recorded?
Yes.
And on that second occasion, Mr. Tubert also informed you that he didn't come forward with the truth or with all the truth because he was afraid.
Correct.
Correct. And did you ask him, did anybody threaten you?
Yes.
And did he tell you someone threatened him?
He did not say someone threatened him.
He did not tell you that Mr. Colon Vasquez threatened him?
No.
Or any of his friends threatened him?
No.
No. He didn't tell him that his family threatened him?
No.
No. Did he receive a letter threatening him or a note?
No, sir.
Text?
No, sir.
No. And was Mr. Tubert also drinking and taking in drugs?
He said that he had been drinking alcohol, yes.
And he was also taking in drugs, right? Or you didn't ask him?
He did not mention that.
Did you ask him?
I don't recall.
Don't recall. Did they describe the caliber of the gun? You know, was it a pistol, or was it a revolver?
He said it was a black gun.
Just the only thing you have is a black. You're Puerto Rican, right?
Objection relevance.
Regards to the music, Your Honor, that was played that day.
Objection relevance.
You know what music they were playing that day? That night or that morning, early morning?
No, sir.
It was not reggaeton?
I would not know.
Relevance. And the witness testified he didn't know.
Did you ask if the room was dark?
Yes.
It was a dark room, right?
People described it different shades, yes.
Yeah, but they told you the room only had a blue light on, which was very low. That's the evidence you received?
I can't answer that because that's not specifically what people said.
The illumination of the room is not important in this investigation?
Yes.
Okay, was the room dark or was it lit? You don't know?
People said that they described it as dark and not that dark, so it was.
You have two different versions.
Two different descriptions of the
Okay.
darkness, yes.
And the music, was it very loud?
Some said yes.
And did you interview all the persons that were in the party?
Yes, sir.
There were how many? About 18?
Probably like 10.
10. And you interviewed all 10 persons?
Yes.
Okay, then, according to the witnesses that you interviewed, the state witnesses here, Mr. Colon was at the party at the time of the shooting.
Yes.
And according to the reconstruction of his cell phone, he was not at the party at the time of the shooting.
Yes, he was.
Oh, yes, he was?
His cell phone was, at least, yes.
Okay, at the time of the shooting?
Yes.
Okay. And the shooting was at 4:37 in the morning, 4:36 in the morning?
No.
No. Okay. What time was the shooting then?
Approximately 3:50, 3:51.
Ah, okay, 3:50, 3:51. But that's not in your report, right? Time of the shooting?
Somewhere in there, there is information to
And
that
did you
effect,
ask
yes.
why Charlene?
I'm sorry?
She took what, 40, 45 minutes or 50 minutes to call 911?
I would approximate there was probably 25 minutes.
Or the 4:35, 45, 50. It took about 10, 35, 45, 46 minutes.
I did ask her that, yes.
You did ask her that. And did she give you an answer?
Yes.
What answer did she give you?
She was distraught.
She was
She
distraught.
was panicky. She didn't know what to do.
And the other witnesses were in the same condition? They didn't know what to do?
The witnesses on scene, yes.
And did you investigate someone by the name of Justin Sanchez? Justin Perez Sanchez?
Investigate?
Yes. Or interview?
Yes.
And do you know his criminal history?
Objection relevance.
Your Honor, it's relevant because he lives at the house and he's a convict. He's convicted of firearms and bodily, and we have it as an attachment in our motion. And he lives with Charlene.
So the court should take into account prior criminal history for propensity for violence in the future?
Well, someone shot this kid. Someone shot this guy.
Sustained.
Mr. Justin Perez Sanchez, did you interview him?
No.
No. Does he live at that house?
Mr. Sanchez?
Yes.
No.
He doesn't live there with his girlfriend? Alondra, did you interview Alondra?
Oh, Alondra. I'm sorry. Yes, she does live there.
So they live at the house with
Yes.
with Charlene? I have no further questions. Thank you.
Thank you. All right. We're going to need to bifurcate this hearing. This hearing was scheduled for 30 minutes. I spoke with Judge Wooten's judicial assistant. She was told by the parties that 30 minutes was necessary for this hearing. We've gone an hour and we're not even through witness number one at this point. I can offer the attorneys two options. Number one is next Wednesday at 11 o'clock. The second option is today at 2:30. Yes.
I'll be available all day today if the prosecutor is available.
Court's going to allot an additional 1 hour at 2:30 today. The jail feed will be in use for initial appearances until about 1:15. No, I'm sorry, until about 2:15, and then I'm going to request that it be transferred back to this courtroom at 2:30. We're going to conclude this remainder of this hearing in 1 hour. Thank you.
You are, be here at 2:30?
Yes, please.
Thank you.
All right, Mr. Colon Vasquez, we're going to continue your hearing at 2:30. Thank you. Officer, I'm going to need the remainder of our morning docket once.
Yes, sir, I'm calling him up right now.
Thank you much. Ms. Broadway, anything we can handle pending the arrival of the inmates?
Your Honor, with respect to Ms. Velasquez's case, if I could approach with the state.
Yeah, come on up. We'll be off the record. Hey, good morning, officer. We have Mr. Brown, Mr. Do we have Ms. Velasquez?
She's on her way up, Your Honor.
All right, thanks. We're going to do Mr. Brown's case. Good morning, Mr. Brown.
Good morning, Your Honor.
Melia Ortega on behalf of Mr. Brown.
Thank you. All right, Mr. Brown is before the court on a request to reduce bond. I note that we had a bond hearing on May 19th where bond was initially set. It's like from my notes, bonds were set in a total amount of $6,000. I assume that's $5,000 as to count one and then $500 as to counts 2 and 3. Is that
I'm not sure the breakdown, Your Honor.
what the breakdown was?
5,000 count 1 and 500 for count 2 and 3.
Okay, so I was correct in my recollection.
And I believe the ASA on this one is Ms. Gonzalez. Should be on. She's going to appear virtually.
All right, thanks. Good morning, Ms. Gonzalez. Are you with us?
I'm here, Judge.
All right.
Sorry.
I apologize for the delay in calling this case. We have Mr. Brown with us on the jail feed. Ms. Ortega is with us here in court, and we are here on the bond hearing. The court noted that we had a bond hearing in May. Court set bonds in counts 1, 2, and 3. Ms. Ortega, what is the change in circumstance that necessitated a second request for a bond?
Your Honor, essentially what the motion is asking for is for Mr. Brown's release with non-monetary release, because since his last bond hearing, he has not been able to post his bond. Mr. Brown is in that position where he maintains his innocence. He wants to exercise his right to a jury trial. As of right now, there really is no foreseeable time frame as to when that jury trial will occur. And so essentially we have someone who has not been convicted of a crime yet, having already served 228 days as of today in jail pending trial. Our arguments, Your Honor, really are just based on Rule 3.131, as well as due process constitutional arguments. Mr. Brown is presumed innocent. His liberty has been taken from him. He's been in there since December 1st, 2019. Right before the pandemic hit, we were ready for trial. We did have a trial date for March 25th. Depositions in this case have been completed. As far as I know, I have all the discovery that I need to go forward. So he's just sitting there, Your Honor, just waiting for a jury trial. We'd be asking for his release. He is presumed innocent. It's a sort of a due process constitutional argument. He has no one to post his bond, which is evident that he's been sitting there for 2 months, and he can't get out since our last bond motion. And Your Honor, I did also want to point out one thing. He is charged with aggravated battery on a pregnant person. Obviously, what makes it aggravated is the status of the victim, not necessarily the actions of the defendant. In this particular case, if you read the report, it's evident what's alleged is a hair pulling. And from depositions, what we know is that the real only evidence that there is the word of the victim. There are no visible injuries, because what she's alleging is a hair pulling. So I would want the court to also consider that in its consideration of releasing Mr. Brown. There is no money amount that would release Mr. Brown, Your Honor. Even if we gave him a $1,000 bond, he wouldn't be able to post that.
Okay. Ms. Gonzalez?
Yes, Judge. So first, I'd like to start off by saying, obviously, what makes it aggravating is that she was pregnant regardless of what the defendant did, but we're not here to argue the facts of the case. There was PC found back during initial appearances on 12/3/2019, which gave him a $6,000 bond. As as Your Honor indicated, we've had a bond hearing in May. I don't believe there has been a change of circumstances, specifically with regards to this case, other than COVID. Arguably, though, that's every single person's argument at the jail, the change of circumstances. I understand that the defendant has due process rights. Unfortunately, though, the victim also has rights. She's currently in the hospital after having the baby, and she's on seizure watch for related issues to the pregnancy that she just had in June. I don't see why the defendant should be ROR'd in this case. He is charged with a second-degree felony, a tampering charge, and the score sheet reads as a total sentencing points total bottom of the guidelines is 23.85. The total sentencing points 59.8. So he is scoring a substantial amount based on the charges itself. He does have two prior cases from 2018. One is an aggravated assault with a deadly weapon. That was against the same victim, and that was not charged. And then I also have a 2018 case, battery on a person over the age of 65, and I believe that that was on the victim's parents. So I don't believe there's been a change in circumstances for him to be ROR'd. The only reason that he hasn't bonded out is because he can't afford it, presumably. Not that anybody is preventing him from bonding out. I also do believe he has issues with immigration court. So being ROR, I think, subjects him to limited supervision with immigration and with our courts. He is pending trial, and if he does believe he's innocent, I think an ROR just gives him an opportunity not to come back. And, I don't agree with that, Judge.
All right, well, the court is mindful of the disruption to the orderly administration of justice based on the COVID protocols. The court, in considering a bond, must take into account a number of factors. In setting any bond, the court does not find that non-monetary release on these allegations is appropriate or warranted. The court finds that the bond amounts are reasonable when considered in all 13 factors required to be considered, and the request to reduce the bond to non-monetary conditions is denied.
Thank you, Your Honor.
Thanks.
Thank you, Your Honor.
All right. Thank you, Mr. Brown. Sorry. How about Ms. Velasquez? Is she up?
Still waiting. She's on her way. We just called for her.
All right, no problem. And is that Mr. Ayala?
Yes, sir.
All right, thanks. I think Mr. LaFay is joining us by video. All right, good morning, Mr. LaFay. Sorry for the delayed start. Mr. Abreu, are you with us as well?
Yes, Judge, can you hear me?
Yes, I can hear you.
Okay, just a moment. Just need to bring camera set up.
Not a problem. We have Mr. Ayala, who is joining us by video feed at the jail facility. This is a request for a plea conference. Is the court being invited to participate in the negotiations?
I am doing exactly that, Your Honor. And of course, I understand the preliminaries that, and number one, I want to thank the court for its participation. Number two, I'd say that, any comments that the court makes are not in the way of any indication of what the court will do in the event that we're hearing where the court might be apprised of more and additional facts. So, thank you.
All right, thank you. And I understand the language indicating that the court will not be accused of vindictive sentencing should a resolution not be accomplished today, and should the court learn additional facts at any future proceedings. How far apart are you guys?
Your Honor, I'm going to be asking the court for for a sentence of 4 months. The state is asking for 9 months. I don't want to take words out of the state's mouth, but that's my understanding of the offer.
All right, thanks. Mr.
And I have
Go ahead.
some items I can advise the board about.
All right, let's start with Mr. Abreu and prior criminal history.
Judge, I had given a source sheet last time we were here in regards to the bond hearing, and it's essentially the argument of the state. He has numerous violations, 1, 2, 3, 4 separate violations, not on our case, ranging from 2009 to 2016.
I recall.
He has the violations in our case, and it just seems it's a revolving door of the same issue. He gets put on probation, he does nothing. Candidly, the state before me probably should not have given probation, but in this case, we have a situation where some people, more than one, lives were in danger due to his actions. He was given a chance to be on probation, and he did nothing about it.
Was this the allegation that had an infant in the vehicle that was hit?
There was an infant in the vehicle, Judge.
All right.
And I mean, based on the nature of the type of case this is, restitution was not something that could be sought out for. So possibly the most difficult part of probation that would have been included had this been any other type of crime other than leaving the scene of the accident with injuries which statutorily bars restitution, there may be a financial concern here for the defendant. Like here, there really isn't. It was no drugs, no dualist class, a basic driver improvement course, not even an advanced driver. He's scoring 38.1 right now. He's a few points shy of being mandatory DOC bottom of the guidelines. I don't see 9 months being unreasonable for someone who's done nothing.
All right, what are we looking at, Madam Clerk, as far as time, sir?
I have 2 days prior to his incarceration this time around, so I think we're at around 10, 15 days, something of that nature, Your Honor.
All right, thanks. Mitigation, Mr. Lefebvre?
So, Your Honor, and I understand, of course, leaving the scene with injuries that there were injuries, but that's a civil matter. Typically, it's not. It was an accident. So it's a negligence issue, and my understanding is further that there are, just on the facts of the case, that there were persons who arrived to assist. Not that excuses Mr. Ayala's conduct, nor would he necessarily have known there was an infant in the car. Although I understand too, you take chances. With regard to probation, and I'm looking, Your Honor, at the Osceola County Sheriff's Office arrest. And, it has for Mr. Ayala permanent address transit. And basically that kind of says it all for what happened here. Mr. Ayala, he was on probation for a couple of months when he was evicted from his girlfriend's residence, in short. So from that point on, he was homeless for several months. And then while being homeless, he ultimately, after a number of months, he got a good job. And that his employer has in fact written the court a letter, which I've attached to my bond motion. So once, which he's had that job for about 2 months, 3 months or so prior to his arrest. But once he became homeless, he didn't have any money, basically lived in his car, and he lived from hand to mouth. So he wasn't paying probation. He couldn't afford the fees to do the classes, and things unraveled from there. And I get it that he had these obligations, but when people live on a string and the sort of damn police cuts the string, then they sort of spiral into the vortex, whatever that may be. And that was, and I understand too that, you know, Mr. Ayala has not acquitted himself perhaps well with previous probations, and this is another one. But if we look at his record, it's pretty much misdemeanors, except for a 2011 sale of cannabis. And the rest is all, and I think there's a driving as an habitual traffic offender. I believe so. But most of this stuff is from 2009, 2016. It's misdemeanor in nature, except for the sale of cannabis in 2009. So really, and I understand that, you know, misdemeanors are misdemeanors, but he has managed to get a good job. His employer has said, you know, he'd hire Mr. Ayala back if it were a matter of some months. Does have children to support. As a sign of good faith, his family has, I can tell the court, paid off all of his court fines or court costs. In the last week, Mr. Ayala didn't have the money, but his family put it together, and they went ahead and paid it. Sort of as a, you know, I guess it's a gesture of good faith. So, and I understand too, you know, that while there may have been a child in the car, nonetheless, this is a third-degree felony. The other thing was a driving license suspended. I think that's somewhat minor in nature, comparatively speaking. So I would basically say, or that's my argument, I'm asking for 4 months and let Mr. Ayala kind of get back to his job and supporting his kids.
Thanks. Mr. Bray, last word?
Judge, I stand by my argument. The crimes that the defendant has in his history all seem to stem from drugs, most notably cannabis. This is another one of those cases that, lo and behold, he had cannabis with him. Allegedly, that's the reason why he stated he was so shook up after hearing that the father was in the other vehicle that he collided with, had a child. That's according to the police report. I'm not going to argue the facts of the case anymore since we're at the BOP stage, but sure. Judge, I don't see any change in this defendant, and the fact that he had a new job for 2 months, those 2 months he's been back on that job, he has done nothing for this BOP.
All right, the court recalls Mr. Ayala's private criminal history. He does not do well on probation. He accepted probation in this case and then proceeded to do 0. That may have been pursuant to his change in life circumstance, but it seems pretty consistent with his performance on probation across the board. Had he been offered a straight jail sentence at the inception of the case, he probably would have been advised to take it. I find that 8 months would have been a reasonable sentence to consider based on the facts of the underlying offense. So if he wants to admit violation of probation, the court will give him credit for the time he's already served, sentence him to 8 months as to both counts concurrently. If he wants to ponder that, Mr. LaFay, I'm fine with that. We can leave it on for the hearing. If he wants to resolve it, I'm happy to do that at your leisure.
Thank you, Your Honor. I'll speak to my client about it, and I'll be back to advise the court of what course of action will be taken.
Thanks, Mr. LaFay. I think we've already got him on our VOP status date for 7/29. Is that correct?
Yeah.
Okay. We'll see you back on the 29th of July, if not before, Mr. LaFay.
Thank you so much, Your Honor.
Thank you, sir.
Thank you.
Thank you, Judge.
Bye. Thanks, Mr. Ayala. All right. How about let's return to Ms. Velasquez. Morning, Ms. Velasquez.
Good morning.
All right. We are here for a bond motion this morning. I understand there's been a stipulation as to an amount. After negotiations with the state of Florida, bond in count 1 is going to be set in the amount of $2,000 as to count 2 in the amount of $500. Any additional conditions will be discussed with Ms. Velasquez, and anything further from defense?
Ms. Velasquez, I will be in contact with you on the video today at 3:30.
Okay.
So if you get started with your bond, I can't imagine you'd be out by then, but we'll be talking then.
Okay, I'll be waiting.
Mr. Tagdieri, anything further from the state?
Nothing from the state, Judge.
All right, thank you. That will conclude our hearing. Thank you, Ms. Velasquez.
Thank you.
Thank you, Your Honor. The public defender has nothing else to be excused.
Of course. Thanks for your patience. It's called Demetrius Cox.
Yes, sir, he's on his way up, sir.
Thank you very much.
Have a nice day, Your Honor.
You as well. Mr. Parker, thank you for your patience. Ms. Pinellas had her hands full this morning. Thank you, Detective, for your patience as well. As soon as Mr. Cox gets up, we will begin. Morning, Mr. Cox.
Good morning.
All right, we're on the record 2020 CF 1115. Court has two motions before the court this morning. Do we need a court reporter for this?
I would request one.
Can you request, can we call down to the court reporters and see if anybody has a live court reporter? It's right before the lunch hour. I don't know if we're going to have the availability of a court reporter.
Thank you. Okay, perfect. Thank you. One's on their way up.
Thank you. All right, we've got a court reporter on our way to the courtroom. Back, Madam Court Reporter. I apologize for the late notice. Thank you. All right, the court's back on the record in 2020 CF 1115. The court had previously addressed the case by digital recording. The court found it prudent to have a live court reporter for this discussion. We are here on two motions. One is a motion for protective order filed by the state of Florida.
Your Honor, actually, there was a notice of cancellation for the protective order because it's become moot at this point.
Okay.
I did file a notice of hearing for the state's motion to strike the defendant's motion for preliminary hearing. That's scheduled for today, as well as the defendant's motion to invoke sanctions.
Okay. All right. What renders the protective order moot?
I was ordered by the court to give the discovery within 10 days.
Right.
That was Monday.
Okay. When was the motion for protective order filed?
Friday. And I asked for hearing time on Monday. I did get hearing time for today. I inquired as to whether I was going to have an extension to disclose the discovery so that we could have the protective order. I did not receive an answer. I also received the court's order on Friday denying the state's motion to stay.
Right.
I did file on Monday as well an emergency petition for writ of certiorari and an emergency motion to stay. However, the court did not answer me before the deadline. And right.
That court. Okay.
And I did email the JA on Monday. I did CC the defense attorney. I did also try and get clarity from this court as to whether I was granted an extension or not. I didn't hear anything back, so I disclosed discovery. The only part that was redacted was the stipulated part from the defense.
Okay. Was there a request to have it heard by our admin judge, Judge Morgan?
No, I didn't request to have it heard on, I just requested hearing time for Monday.
Gotcha.
And then I asked if I was going to get an extension, and I received hearing time for Wednesday, so I may have misinterpreted that. And then the defense.
On COVID protocols, the first available time that the court has access to the jail feed is on Wednesday. Judge Morgan typically has it on Monday, and Judge Wooten typically has it on Tuesday. So I know things are in a little bit of a state of flux, but moving forward, that will be the situation for the foreseeable future. Mr. Parker, is that, are you still requesting to move forward with your motion to invoke sanctions?
Judge, I am, and I just wanted to lay out a few of the procedural things that have occurred from my perspective. So we were here on July 1. The court ordered them to turn over the discovery within 10 days, which would be July 11. So the state filed the motion for reconsideration and then waited a few days until that was decided. And at that point, I think that they were in a little bit of a scramble to do either an emergency writ and ask for a stay from the 5th DCA because the writ did not have a proper appendix. The DCA wasn't in a position to do a stay for the writ at this point, which they may do this week, I don't know. But they delayed disclosing discovery. Looks like Monday, I still have not received discovery by 12 o'clock, knowing that the Arthur hearing was going to be set for today. I did a notice of cancellation of the Arthur hearing about 11 p.m. And I did receive the first piece of discovery disclosure at 4:58 p.m. on Monday, which again would have been about 2 days late at that point. So preventing me from preparing for the Arthur hearing so that I could eventually get my client released today. Their delay has caused my client to inevitably sit in jail now, I guess, until we can get a new Arthur hearing, unless the court finds that the state's willful disobedience of this court's order is grounds for the court to set reasonable bail, and that's what we're asking for you to do today. Judge, there's no excuse for them to disobey a court order. I understand that they filed a motion to reconsider. That should not have prevented them from doing redactions, which would have needed to have been done anyways, and apparently were done in time to disclose what they have in their possession on July 13th. So, Judge, they've again delayed and hindered my ability to do my job, and again prejudiced Mr. Cox in this matter. So we're asking for the court to set bail today at a reasonable amount. I can take testimony from Mr. Cox as to what that would be. Thank you.
Thank you. Last word, Ms. Spino.
Your Honor, the 11th of July was a Saturday. Monday was the 13th. I did wait candidly until 5 p.m. when I knew the Fifth Circuit was going to close. Close of business is 5 p.m. I disclosed all of the paper discovery to the defense via email, at which point I realized that I was not going to receive a stay. I also emailed the defense attorney and advised him that I had emailed him everything that I potentially could. Everything else was on a 2 terabyte hard drive. I advised him that it would be available for pickup in the morning, and as far as I know, the defense picked that up today. The defense did not pick that up at the earliest point in which he could. I do not agree with the defense counsel's representation that the state willfully and intentionally and flagrantly violated the court's order. The court said 10 days. I gave, the 10th day was on a Saturday. I gave all of the discovery that I physically could turn over on Monday through email and made all of the rest of the discovery readily available. These are pretty significant allegations set forth in the defense's motion to invoke sanctions. I would also point to the remedy that the defense is asking for. I don't think that that is an appropriate remedy should the court find that the state violated the court's order in this case. I don't think that setting a bond for the defendant is the appropriate remedy.
Any pleadings filed in the court file that requested an extension of that 10-day period?
No, Your Honor.
Right. Based on the circumstances before the court is going to find that although the court's order was violated, it was not a willful material violation that warrant the sanctions requested of consideration of bond absent a full Arthur hearing to determine whether proof is evident, presumption great. The court finds that the state of Florida was appropriately seeking appellate remedy in this unusual circumstance, and perhaps a matter of first impression requiring the transmittal of information and discovery pursuant to Rule 3.220 in advance of a formal charging document. That's been thoroughly discussed at the previous hearings. The court finds that the state of Florida seeking appellate review appears to be appropriate, and based on the timing of their request for a stay with them, that the transmittal before the end of business on Monday, although arguably outside of the 10-day order, is not a willful material effort to circumvent the interests of justice. So the request for the sanction of considering bond in absence of an Arthur hearing is denied. The court finds also that the 2-day delay, although necessitated the resetting of Arthur consideration, that prejudice is de minimis based on the length of time Mr. Cox has been in custody, the allegations against him, and the previous litigation as to this unique issue. So the request for sanctions is going to be denied. Apparently the motion for protective order is now moot. That leaves the state's motion to strike the defendant's motion for a preliminary hearing. Ms. Pinnell?
Your Honor, I set out the grounds for the state's motion to strike within the motion. the state's position is the appropriate time for an APH, adversary preliminary hearing, to be sought is 21 days after the state actually can engage in grand jury proceedings and after the lift of the suspension by the Supreme Court.
Thanks. Mr. Parker?
I would agree.
Yeah, I think I'm bound by the Supreme Court order in 20-23, Amendment 5, which extends the time period out for the stay out to July 26th. Quite candidly, I anticipate that date's going to slide further, but at this point, I'm bound by that precedent. So the motion to strike the defendant's motion for a preliminary hearing is granted with leave to refile upon the lifting of that stay.
Thank you, Judge.
Thank you.
Have a great day.
As well.
Can I get a point of clarification for this case going into the future?
Yes.
Obviously, I am working with law enforcement and potentially receiving additional discovery in the future. Is the court's order specifically to what the state has in its possession now, or is the court ordering the state to participate in ongoing discovery? Also, is the defense required to provide any defense discovery?
Yeah, Mr. Parker, what's good for the goose is good for the gander. If we're beginning the discovery process, is there argument that the defense is not also bound by that mutual discovery?
Yeah, I have no problem with that.
All right, so the court's going to find that the state's discovery obligations moving forward is continuous as they gain additional information they intend to be used at in the prosecution of Mr. Cox. That will be a reciprocal discovery obligation on the defense with all the appropriate sanctions should those discovery orders be violated to be considered by the court, and the court will consider motions for protective order as that information comes in, should it jeopardize a continuing ongoing investigation, or should there be allegations of threats to witnesses.
On that particular subject, Ms. Pinnell has turned over everything in her possession with the appropriate redactions that were stipulated to at the last hearing.
Thank you.
There were witnesses' names that the police had redacted essentially or anonymized in the discovery. I don't think that they're in violation of any order by turning over what the police had essentially produced to them. So I think it would be appropriate to readdress those issues as far as disclosing anonymized names in a separate motion at a later date.
Okay. I assume at some point that matter will correct itself pursuant to the charging of formal by formal indictment, but I don't know at what point.
Just for the record, all of those witnesses that are referred to as witness 1, witness 2, witness 3, all of their statements recorded were given to defense, and all of their names are in the statement. So if you listen to the recordings, you can ascertain who is witness 1.
Right. I don't know whether there's been a violation of the discovery order at this point or not. It seems like this may be anticipatory. So if there's a specific alleged violation of the discovery, I can handle those issues on an issue-by-issue basis.
Thank you, Judge.
Thank you. Thank you for being present. Right, that's going to complete our morning docket. We will be in recess until 2:30 in this courtroom. Madam Court Reporter, thank you. Thanks, Corrections, if you're still out there. Appreciate it.
Okay, folks, this is not really an in-person hearing, and I cannot see when the mask is fogging my glasses. Everyone is at least 6 feet away from me, I would say probably about 12 to 15. And so I am going to remove this so that I can articulate myself, so that I can be heard, as well as so that I can necessarily see. The rest of you, feel free to do what you wish, as long as you're maintaining 6 feet from each other. But I need to do this in order to do my job. All right, so I'm going to begin with, I guess it's this list on the left. Is it John Doe 3117?
Katie approved?
Okay, the public defender is appointed in this matter. And in terms of the Spanish interpreter, I'm not sure how we're doing that. Okay, this is a different apparatus.
Good morning, Your Honor. This is Carlos Morales, State Certified Spanish Court Interpreter. Interpreter has been sworn in already today.
All right, good afternoon, Mr. Morales. We have case 20 CF 1983, State of Florida versus who has been designated as John Doe 3117, also known as Emerson Calix Zuniga. Sir, please state your date of birth.
I'm sorry, Your Honor. Is the defendant in the courtroom or
He's
in
at
jail?
he's at the jail. We're here for jail arraignment, so he's at the jail.
Okay. ¿Cómo se llama usted, señor? Emerson Calix.
Date of birth?
Fecha de nacimiento?
15 de junio de 2002.
2002?
Sí.
June 15, 2002.
Okay, one moment.
Un momento.
Having reviewed the police report, I find probable cause for aggravated assault.
Habiendo leído el informe de la policía, determinó que hay motivo fundado para la acusación de amenaza agravada.
Mr. Akendo is present from pretrial release, PTR. Mr. Akendo, history?
Judge, the defendant has no prior criminal history, but does have a detainer for immigration. Immigration states that there's a warrant for deportation.
Bond in this matter will be $1,000. Mr. Doe 3117 must have no contact whatsoever with Nelson Camacho and must not possess any weapons or firearms.
Muy bien, entonces determino que en este caso al señor, al acusado, número 3117, la fianza es de $1,000 y también le está prohibido el contacto directo o indirecto con Nelson Camacho y le está prohibido poseer armas o armas de fuego.
And the next court date, Madam Clerk?
Next court date on demand.
La próxima vista se anunciará cuando se tenga la fecha.
Thank you, sir. That concludes this hearing.
Gracias, señor.
Tengo una pregunta.
I have a question.
Okay.
Sí.
¿La fianza la pueden pagar hoy o tengo que venir otra vez a corte?
The bond, can I pay the bond? Can it be paid today or do I have to come back to court?
You have a $1,000 bond in this case today. I've been informed that there are other matters that may be detaining you, such that if you posted bond, it might still be the case that you're not released. All I can tell you is you have a $1,000 bond in this case, which could be posted today, yes.
Bien, bueno, ya como le dije, le he asignado una fianza de $1,000 en este caso. Sin embargo, me han informado que hay otros casos pendientes en contra de usted donde es posible de que aunque usted pague la fianza, quizás no pueda salir. Pero la fianza que se le ha asignado el día de hoy, en este caso que es de $1,000, usted la puede pagar hoy.
Okay, gracias.
Thank you.
Okay, thank you.
Okay, I neglected at the outset to have parties put their names on the record here this morning. I think I was flummoxed by all the fog. From the State Attorney's Office?
Maria Morales on behalf of the State, Your Honor.
From the Public Defender's Office?
Sarah Jordan for the Public Defender's Office, Your Honor.
Oh, it's Ms. Jordan back there. I didn't recognize you. And think that's Mr.
Officer Ray Oquendo, pretrial release.
All right, Joshua Miller,
PD approved.
public defender appointed. All right, Mr. Miller, you have counsel. I've appointed the public defender. I have reviewed the police report. I do find probable cause for the listed offenses. Actually, I don't need to find probable cause because a prior court has and issued a warrant for which you've been arrested before determining bond conditions that may be appropriate. History, Mr. Oquendo?
Defendant has history going back to 2008, charges of assault, battery, dealing in stolen property. Most recently, January 2017, possession of controlled substance, possession of marijuana, carrying concealed weapons. He was found guilty on that. We were able to make contact with 2 of the 3 victims, Miss Teresa, the grandmother, and Alexis, and they are requesting no contact. That is all, Judge.
All right, thank you. Bond on the aggravated battery will be $2,500. Bond on the battery will be $500. Should you make bond, you're to have no contact with Alexis Gavin, no contact with Teresa Mahagan, not to return to 1511 Pennsylvania Avenue in St. Cloud. If that was your, no, that's not your permanent address, I don't believe. I believe you're on Illinois.
Yes, sir.
Okay, all right, so those are the conditions. You're also not to possess any weapons or firearms. And your next court date, sir, will be announced.
Next court date on demand.
You'll receive it. Thank you.
Thank you.
David Andino,
PD approved.
public defender appointed. Hello, sir. Good, thank you. I will appoint the public defender, and I find probable cause on count 1 for the lesser included offense of possession of cocaine. Count 2, possession of drug paraphernalia. Count 3, possession of documentation in the similitude of an identification, but not a valid identification. And then count 4, providing false identification information while lawfully detained. So, Madam Clerk, on count 1, that's the lesser included possession of cocaine. Mr. Oquendo, history?
Defendant has local history starting in 1988, charges of burglary with assault, smuggle, contraband, failure to appears, grand theft. Has history out of the state of New York, starting in 1986 with criminal mischief, petty theft. There's an arrest coming in January of this year for burglary. We do not know the disposition on that. Pennsylvania, receiving stolen property, burglary, theft, and out of Georgia, burglary, fraud, and possession of weapon. That is all, Judge.
All right. Bond on count 1, possession of cocaine will be set at $2,000. Possession of drug paraphernalia, $500. Count 3, the possession of the fictitious ID card will remain $1,000. And your bond on count 4, false information, will be $1,000. Subject to pretrial release supervision. You're also not to possess, ingest, or consume any illegal substances or any controlled substances without a prescription, and you're subject to random drug testing. So make sure you're not ingesting any illegal substances or controlled substances without a prescription. Your next court date, yes, sir?
Excuse, Your Honor, is there any way, my whole bill could be $5,000 for my niece to come and pay for me, and I could go to a drug rehab this week? I could get into a drug rehab?
Well, I didn't aggregate your bonds for you. I gave you the amounts for each.
How much is that?
Yeah,
I can add it, Judge.
okay, we have a mathematician momentarily here.
4,500.
4,500
Total?
total.
Okay, thank you, sir.
All right, thank you.
I'm gonna go get into a rehab as soon as I get out.
That sounds like a plan. Thank you. All right.
Thank you, sir.
Next court date on demand.
Okay, thank you, Madam Clerk, for the math. Raynor Calhoun,
PD approved.
public defender appointed. Hello, sir. I have reviewed the police report. In this case, the court finds probable cause for the listed offenses of battery and ag assault. Mr. Oquendo, history?
Defendant has history going back to 1999, possession of marijuana under 20 grams, possession with intent to sell, several driving away license suspended, Most recently, 2018, driver license suspended, second offense, he was found guilty. He's out on bond for Broward County for another driver with license suspended, habitual. And the victim for this case is requesting contact.
Okay, your bond on count 1 will be $500. That's the battery. Bond on count 2 will be $2,500. Should you make bond, you're to have no hostile contact with Vincent Isaiah Miller. No hostile contact obviously prohibits any acts of violence or any threats of violence or acts of intimidation. You're not to return to the Parkway International Resorts at 6200 Safari Trail. You're not to possess any weapons or firearms. Your next court date as follows.
Next court date on demand.
Thank you.
Your Honor,
Yes.
may we inquire if the defendant has any personal belongings at that location?
Mr. Calhoun, your attorney had a question. I ordered that you not return to Parkway International Resorts. By chance, do you still believe you have personal belongings at that location since it was a lodging establishment?
As far as I'm aware of, no, sir.
Okay, all right, thank you. All right. Let's go to Manuel Laureano,
PD approved.
public defender appointed. All right, sir, hello. You have a lawyer. I've appointed the public defender. I have reviewed the police report, and I do find probable cause for a misdemeanor battery. Mr. Oquendo.
The defendant has history going back to 2018, tampering with evidence and destroying documents. Those charges were dropped. History out of New York in 2004. Petty larceny, damage to property, no disposition on those. The victim is in jail, and she is requesting contact.
All right, bond will be $750. Notwithstanding the victim's request, I am ordering that you have no contact whatsoever with Ms. Veronica Fernandez. None means none. No emails, no text messages, no communications, and you're not to possess any weapons or firearms. Your next court date as follows.
If still in jail, July 23rd. If out, August 14th in courtroom 4E at 2:30 p.m.
Thank you, sir. Christopher Sullivan,
PD approved.
public defender appointed.
Yes, sir.
Good afternoon. The court finds probable cause for trespassing in the matter. Just one moment. All right, unfortunately, Mr. Sullivan, you are on pretrial release in a felony case, 20 CF 1905 in front of Judge Wooten. Your PTR in that case will be revoked. The court will give you a bond of $250 in this trespassing case. You're not to return to the Walmart at 4444 West Vine Street. Again, public defender's been appointed. It'll be a PTR revocation with a zero bond on 20 CF 1905. All right, thank you.
Next court date if still in jail, July 23rd. If out, August 10th in courtroom 4A at 9:30 a.m.
Sorry, Your Honor, did you stay his current bond? Is that what?
It's current bond 250 on the trespass, yes. Is Mr. Kenneth Walsh still in the building there? Okay, yes.
PD approved.
Public defender appointed. All right, Mr. Walsh, I have reviewed the police report. I find probable cause for the listed offense of aggravated battery on count 1. However, lesser included offense of assault on count 2. Before determining bond and any conditions that may be appropriate, Mr. Kendo?
Defendant has history going back to 1977 with no valid driver's license, failure to appear, charges of disorderly intoxication. Most recently, last arrest coming in 2013. Total of 3 domestic batteries with a violation of an injunction. One of those domestic batteries was found guilty. We do not know if it's the same victim. We were not able to contact the victim today.
Okay, the bond on the aggravated battery will be $1,500, on the assault $500. Should you make bond, it's supervised by pretrial release. You're to have no contact whatsoever with Marvin Wilson. I realize he's your brother, but no contact. You must not return to 201 Simpson Road, apartment 246. However, if you have personal belongings at that location, such as toothbrush, toiletries, clothing, you may return to that location one time with the assistance of the sheriff's office for acquisition of those belongings. I know you have a question. I'll come to that in a minute. You're also not to ingest, possess, or consume any illegal substances or any controlled substances without a prescription. And this will be subject to random drug testing while you're on pretrial release. I believe you had a question. Your attorney is here, and you have the right to remain silent. Ms. Jordan?
Your Honor, I believe the affidavit indicated that Mr. Wilson was leaving the residence. Would you would you agree to allow him to return to that address if PTR confirms he has moved out?
And Your Honor, they would concur with that.
Okay, so the order is that you not return to that location, 201 Simpson Road, apartment 246. However, I'm giving an assist order with the sheriff's office to get personal belongings. If pretrial release confirms that Marvin Wilson no longer lives at that location, then you would be able to return there and stay and live there. You want to, yeah?
Your Honor, that's my address. I was letting my brother stay there. He's been on the street for 15 years. He's a homeless person.
Okay, I'm going to just leave the order as it is, all right? If PTR confirms he's no longer living there, then you could return there, all right?
Yes, sir. I'm the only one on the lease, Your Honor.
Right, so you can talk to your lawyer about any actions that you may be able to take if you wanted to have him removed by virtue of an unlawful detainer or other eviction type action. But you have to comply with the pretrial order I've given, all right?
Yes, sir, I will.
All right, good luck. Thank you, sir.
Next court date on demand.
Okay, so we'll let corrections populate the room, and then we'll take the rest of them. No. Okay, thank you, sir. In the meantime, I'll mask back up. I'm not being a rebel. I just can't see. Yes. I should wear my contacts today.
Your Honor, if I may have a moment when they arrive to speak to one of the defendants.
Of course.
Thank you.
Looking for the hand soap. I'm good. I'm good. I just didn't want to endanger you. I'm good.
Oh, no, I have some here.
Is that masked Miss Salsa down there?
Oh, oh, she's gonna be the new.
I heard that. I heard that. Congratulations. That sounds like a great move.
Well, we shall see. But I think so.
Yeah.
Once I learn it.
I just remember the avalanche that's in civil. Of course, I guess it slowed down with no evictions, but.
Yes, quite so.
Yeah. Just for everyone's benefit, I know we're waiting. On the Veronica Fernandez case, did y'all get word, I'm sorry to interrupt you, you got word that the Fernandez case was reset it's a competency status hearing set for tomorrow?
Yes.
Yeah.
Yes.
It's one of those deals. She got picked up on a warrant for failing to appear, and I said to bring her before the court within 24 hours. So we're holding the competency status hearing tomorrow with her PD after jail arraignments, yeah.
I have it on here on the order too.
Okay.
So she won't be at court today, Judge?
She doesn't need to be. They may bring her in if word didn't get there in time, but.
She's the victim of Mr.
Yes, I saw that. Yeah, I saw that. Yeah, the street deal that happened.
Right.
Yeah. Yeah, I just didn't want her to languish for a few weeks, given the nature of the proceedings. It's she FTA'd on a competency status hearing, actually not too long ago, a few days ago.
Is it in your courtroom?
Yes. And she just happened to get picked up, I guess, because of this.
Yeah, I saw that. Like she's the victim.
Yeah. Huh. He's gonna let him know I won't be there till about, close to 2. Maybe 1:50 or so, if they get him in there, well, 2. So are you in Judge Wooten's division?
No, I'm research and writing.
You're what?
Research and writing.
Oh, research and writing, you're appeals and 3.850s or
I'm sorry?
3.850s and,
Sometimes.
well, actually, not a lot of that, I guess, because you're, yeah. Writs.
Yes, I do file the writs.
My favorite 2 years as a lawyer was doing appellate work. I was the appeals person in the state attorney's office. That was way back in the early 90s, but I loved it.
I enjoy it a lot.
I've got about 110 briefs, appellate briefs, that are still in boxes at home. I still haven't trashed them. You put all that work into it, it's like, I can't throw these away.
Yeah. Stacks and stacks of paper in my office.
We used to do oral arguments. You don't do a lot of that anymore in county to circuit appeals. That you just wait for a ruling. But we used to do oral argument. It wasn't a 3-judge panel though. Back then it was just whatever circuit judge it went to. So it was just one judge.
Oh, okay. I just got my first reverse and remand for discharge from Judge Tennis.
Oh.
So, the writing, the opinion judge.
She was the circuit, oh, okay.
Yeah, she wrote the opinion.
It was not in my division, was it?
No, it was Judge Draper. It was a trial for Judge Draper.
So,
on a motion to suppress.
You gonna count that as a win? I'm teasing this. Well,
I used to always say I'm so glad when I did initial appearances that Judge Draper never asked my name because I had a feeling she would know it.
Yeah, when I used to do appeals,
the things I filed.
we had, you know, I'm not naming names because we're going back to like 92, 93, but there were 3 or 4 county judges in Orange, and the reversals just boom, 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 boom. You know, I don't know if it was they were trying to dismiss for docket control, but it made the appeals easy. You know, you gotta have grounds to dismiss a case. So, I want to tell you a funny appeal story sometime when we're in a smaller environment. It's a lot of fun, a briefer. Let's see, can I go totally off record here? How do I do that? Off record, okay. So, I'm gonna take my glasses off. I can't see 2 feet in front of me, but I can tell this story without naming names. So, there was this case that was, it was a great case for a state appeal. It was like a slam dunk win, right? And the transcript, as you know, you have to order all the proceedings and everything. And during the course of the trial court explaining his ruling, he said this, and this is a direct quote. He said, "It's not my job to make intelligent decisions." Now, what he was saying in context was, I'm just following the law. But it was a very bad decision, in my view. And so, you know what I used as the lead into my brief. I put it in quotes. And then the very next line was, the lower court fulfilled its own description of its. That was fun. Lots of fun. Okay. A little sassy. We ready? Let's see. Get the mask. I don't see all the group in there.
I think the ladies are on the side and we can never see the full room.
So we're segregated by gender.
Yep.
Allowed to do that?
I guess.
Okay. These are not all ladies. You said James Neary is still in
The hospital, yes. Do you want to reset him for tomorrow or for when available?
for tomorrow or what?
Or for when available? 'Cause I don't know.
Yeah, 24 hour, as soon as the person is back in custody.
Okay.
varieties.
Okay. Okay, so when he says, they say things like that?
I didn't catch your last name.
Morales.
Morales.
Yep.
Morales, thanks.
Because I studied.
It doesn't matter. Honestly, you can. That's all because it's more for the jail, so they know, okay, they want to know what happened. Oh, we got reset because of this. Okay.
Mm-hmm.
Thank you, Your Honor.
I'm gonna take this with me so I can just look them up and.
Yeah, that's fine, that's fine. I'll let the girls know. If you want, you can have Brenda just call me whenever you're ready.
Sounds good. All right, your name, sir? All right, Mr. Rivera, I'm Judge Epperson. We're here for initial appearance. Now, did these folks see the video or no? No? Okay, so this is a very brief hearing, Mr. Rivera. Its primary purpose is for the court to review police reports or affidavits to determine whether there's probable cause, and if there is probable cause, to determine whether bond's appropriate and what conditions of release might be appropriate. You do have the right to counsel. You also have the right to remain silent today. You also have the right to consult with family and friends concerning this case, subject to the reasonable restrictions of the jail. Does Mr. Rivera qualify?
Yes, PD
Okay.
approved, Judge.
I'm sure you told me that a moment ago. Mr. Rivera, I am appointing the public defender to represent you in this matter.
We would request that you waive the reading of this charges.
All right, there's a request for a waiver of the reading of the charges. I've reviewed the affidavit, and it does have sufficient facts to find probable cause, and I find probable cause for the listed charge. Mr. Okendo from pretrial release, history?
Judge, the defendant has history out of state, out of New Jersey, dating back to 2018, possession of controlled substance, receiving stolen property, theft. One case, prior case here in Osceola, January 2020, domestic battery, criminal mischief, persisting without violence. The defendant was sentenced or adjudicated withheld for the domestic battery and placed on county probation. He never reported. We will be requesting a revocation of that.
All right, the court, having found probable cause for the listed charge and all the circumstances, I'm going to set bond in that case at $50,000. You're to have no contact whatsoever with Destiny Rivera. That's no contact. That's no third-party communications, emails, text messages, phone calls, obviously no direct contact. You're not to return to the location of 1983 Kimlin Circle. That is designated as your permanent address. So if you have personal belongings such as clothing, toiletries, toothbrush, articles for your employment, I would grant a one-time return with the assistance of the sheriff's office for the exclusive purpose of acquiring those belongings. You're also to have no unsupervised contact with any minor. And in 20 MM 30, the case for which you're on probation, given the time that this new offense is alleged to have occurred, I do find an on-view violation of probation, and there will be a zero bond on that case, 20 MM 30, based on the on-view violation, and probation will have 24 hours to consider following through with an affidavit. Your next court date as follows.
Next court date on demand.
You'll receive it. Thank you. Myron Sinclair,
PD approved.
public defender appointed. Hello, Mr. Sinclair. There's two separate case numbers. I'll deal with first 20 CF 1985. Having reviewed the affidavit, the court does find probable cause for the listed offenses of kidnapping or false, I'm going to say false imprisonment on this case, all right, false imprisonment, 78702, possession of a firearm by a convicted felon, and battery.
I've never been convicted of a felony. I wanted to speak to you on that charge because
Okay, well, you are, of course, presumed innocent of the charges, and what the court says today is not a verdict or a final judgment. It's just a probable cause finding based on what was asserted. But let me look at the report again, just a moment. I think it was toward the end. No, I saw a sentence on that.
The bottom of the second page.
State of criminal history was ran the suspect. He has a past criminal record of a felony conviction. Okay, so you and your lawyer can pursue that further. I do have a sworn statement, and that's all I can rely upon today that does reference a felony conviction. All right, yeah.
I'm sorry, if I may, I'd like to contest probable cause listed battery in this case.
On the which one?
Battery, touch or strike.
Battery, what was the next thing you said?
In this specific case.
Okay, yeah, I realized it's predicated upon the shoving of her legs aside before he allegedly took control of the car. Your point there would be? That
it wasn't, no evidence of specifically an unwanted touching in that case, just she didn't want to drive the car anymore, so he took action.
Okay. Morales?
State would disagree. I believe the situation was that she was trying to comply with the officer's order, and once he realized that she was trying to comply with the officers, he moved her out of the way, that way she could. That doesn't imply consent, because she was trying to get freed. Also, I don't mean to go on about it. I believe the possession of a firearm, it probably should be by somebody found to be a delinquent. And I have a case number. I found it on, if you'd like me to say it.
Sure.
It's out of Broward County. It's uniform case number 06-2017 CJ 484. He was found delinquent in juvenile court on burglary, grand theft, and criminal mischief.
Okay. The court has no way to determine whether or not the assertion in the police report concerning the felony conviction is for that delinquency. I mean, I appreciate that information. It's good, important information. I have no way to know whether or not he was designating that offense, so I'll go ahead and maintain it as I've indicated based on the sworn affidavit. With regard to the battery probable cause argument, it's a reasonable argument. I actually gave consideration to that point as I reflected on the factual bases for all of these allegations. It's not a situation where someone punches someone in the face. It was the conduct was described as shoving her legs away so that he could take control of the car, which in the context of the events would seem to have been against her will as she was attempting to comply with the directives of the law enforcement officer. And so I think the circumstantial evidence is sufficient for a threshold finding of probable cause, which is a lower standard than beyond a reasonable doubt. But Ms. Jordan, I did reflect on that very issue as I was considering the case, so I think it's a reasonable point. I'll maintain the probable cause findings, however. On the companion case, 20 CF 1988, the court finds probable cause for fleeing and eluding law enforcement officer. There was a listed charge of driving without a valid license, but I'm not sure I saw that. Just a minute. Okay, yeah, there is a sworn statement to that effect as well. So I find probable cause for the no valid driver's license. Mr. Okendo, history?
Defendant has juvenile history going back to 2016, charges of battery on public employee, simple assault, domestic. Has a 2017 charge for escape from a detention facility for a juvenile. He got recently released from DJJ custody on March of this year. And there's a detainer in place for San Lucie because this is a over-the-line arrest. And that is all, Judge.
Right. On false imprisonment, count one, $5,000. Possession of a firearm by a convicted felon or delinquent, the bond will be $2,500. On the battery, it'll be $500. That's for case 20 CF 1985. You're to have no contact whatsoever with Ms. Carell Affleck. No contact means none. With respect, yes. Who's speaking? Okay, with respect to 20 CF 1988, fleeing and eluding, your bond will be $7,500, $500 on the no valid driver's license. And defendant, I'd like the defendant to be supervised by pretrial release. He's eligible for that?
I do not, he does not, Judge, because this is a over-the-line arrest. This is an actual case for San Lucie. I believe that the detainer in place is because they're going to transport him to San Lucie. So therefore, he won't be able to be supervised by Osceola County pretrial release. The affidavits are used by, they use are the Osceola County Sheriff's Department, but this is an over-the-line. The crimes were committed in San Lucie and...
Okay, I had the impression that, just a minute. Well, I'm going to stand by my findings in 20 CF 1985. Those events are described as occurring in Osceola County, even though the pursuit commenced in St. Lucie. But let me turn back to the 1888 case and give another review of the...
I believe the kidnapping, possession of weapon, and battery happened in San Lucie. And as far as I can remember, the detainer for San Lucie requested zero bond on all those three charges.
But But he ran off the road at Yeehaw Junction. Okay, so on scene, I suppose he attempted to stop the vehicle in which led pursuit north on the turnpike and made a right turn onto Yeehaw Junction and veered off the roadway into the grassy area. The victim who stayed in. Okay. Okay, all right, let's see. All right, the violation locations described in the affidavit as northbound turnpike SL, which no doubt stands for St. Lucie, given the other readings. So I'm going to set aside everything I've just said concerning bond amounts, and he's going to remain on hold. And St. Lucie will have 24 hours to pick up the defendant on these charges. All bonds will remain as they've been set right now. If the defendant's not picked up within 24 hours, he should be brought back before the court, because St. Lucie, I think, is within that 24-hour region.
So Judge, repeating the 19, case 2020 CF 1985, count 1, 5,000, count 2, 25.
No, I'm sorry. Yeah, thanks for asking. No, all of the bonds are going to remain as zero. There's simply a hold on him for St. Lucie, and then St. Lucie jurisdiction will deal with these matters when they pick him up. So they have 24 hours to pick you up, Mr. Sinclair. Thanks for the clarification.
Yes, Judge.
Mr. Okendo. Ms. Jordan, did you have a question?
Yeah, pardon me. I was unclear as to when the alleged, I believe the false imprisonment, is that a traveling charge, or is that they're going to presume it began?
Yeah, it looks like that these are all being alleged as St. Lucie offenses, even though I know the pursuit ended in Osceola County. And that was kind of what threw me as I was reading them, was that it was, some offenses are ongoing offenses and they can occur in multiple jurisdictions. And so, but as I read it, it appears to be St. Lucie Sheriff's Office bringing the charges for all of the events that are identified in the report.
Zero bond right now, St. Lucie.
It's just a pickup, a hold for St. Lucie County, yeah, for 24 hours, and if they don't pick him up, then he can come back before the court. Yeah. Okay, Erica Ortiz Colon.
Katie approved.
Hello, Ms. Ortiz. I have reviewed the police report. I find probable cause for resisting an officer without violence. However, on the driving while license suspended charge, I know actual physical control applies to a DUI. I'm not so sure it applies to a Dwillis.
Right, and Your Honor, ASA Baird, which was covering the IAs yesterday, had requested a supplemental report. We got our supplemental report. We didn't get the sworn affidavit. We did request a sworn affidavit. We didn't get it, so.
Okay. Okay, so Ms. Ortiz Colon, public defender is appointed to represent you in these matters. I do find probable cause for the resisting, or was that already found yesterday?
It was already found.
Okay, and she was given a bond on that?
Mm-hmm, just the duelist was the one reset to today.
Okay. Well, you have to have a sworn statement, so based on the limited information I have before me today, defendant will be ROR'd on the driving while license suspended matter. Now, let's see, is there I've got a notation on here about a VOP.
Yes, Your Honor. The defendant is on VOP in Osceola County for 2019 MM 1866, and there's also an open Orange County case for a Dwillis. That's 4820 CT 2651. But I'm not sure what action was taken yesterday. I don't have that documentation.
Judge Morgan took no action on the case from Orange County that she's out on bond.
He took no action on that?
He took no action, Judge.
Okay, That was the Orange County out on bond.
What was the case number for the VOP?
2019 MM 1866, and that's here in Osceola.
Okay. And what's the charge in that?
It was possession, I want to say paraphernalia and a duelist. Let me look it up just so I can make sure.
Yes, and that's it. Judge, I'm printing the VOP now for that case. Well, the VOP was seen yesterday in court. Judge Morgan left it at a 0 bond. Her next court day in front of Judge Arendis.
Okay.
is-
So no further actions needed then. All right, so to summarize, released on your own recognizance on the driving while license suspended charge. All right, thank you. Have we covered everybody? No, sir. One left. Okay, that surprises me. Who might that be?
Ms. Veronica Fernandez.
Okay, yeah, we can bring her up. Hello, Ms. Fernandez. I'm Judge Epperson, and the reason you're in custody, you failed to appear for a competency status hearing in front of the court. And so for that failure to appear, a capias was issued. That's been affected. Your lawyer and yourself will appear before the court tomorrow for that competency status hearing. I believe it's at 11 a.m. or it's mid-morning.
10 a.m.
10 a.m. All right, and your lawyer will be here for that hearing. All right, she's going to be added to the jail arraignment list tomorrow. Not for a jail arraignment, for competency hearing. All right, thank you. Yeah, bond, sorry, bond stay. Thanks. Okay, everyone, thank you, and we are in recess.